Okay, I'd like to call to order this March 6, 2019 meeting of the Full Sunshine Ordinance Task Force
Time is 4:10.
at 4:10.
Thanks. Item number one. Item number one, call to order, roll call, and agenda changes. Matthew Kate, absent. Lila LaHood.
Present.
Josh Wolf, absent. Rishi Chopra, absent. Luam Tesfaye,
Present.
present. Rodman Martin,
Present.
present. Frank Canada,
Here.
Frank Canada, present. Vice Chair Hyland,
Here.
Chair Hyland, present. Matthew Yankee, Matthew Yankee, present. Fiona Hensey,
Present.
Fiona Hensey, present. We have a quorum.
And just a note that Chair Wolf is on his way up shortly.
Through the chair, can I make another note?
Sure.
Matthew Kate did let us know that he would not be present today, so.
Oh, right.
Yeah, he's
he
not
did
going to
it
be
the
back
last
until May. Yeah, we know
Yeah.
that.
Okay, good to know.
Okay.
Thank you.
Now, agenda changes. There are a couple.
All right.
I received word this morning from Betty Mackey that she had a conflict.
Which item is this?
This is item number 4.
Okay.
That she had a conflict. She asked about having a proxy, someone represent her at today's meeting. I told her I needed a signed letter from her stating that that would happen. And as of when I came up here to start preparing at 3 p.m., I hadn't heard a word.
Okay.
Okay. Another agenda change, item number 9, file number 18072, complaint filed by Joshua Clipp against the Recreation and Parks Department. Rec and Park was unable to get a representative to prepare for and attend today's meeting. And I told Mr. Clipp this, and we have marked this for the next meeting, which would be in April. I believe it's April 6th.
Mm-hmm. And when did Rec and Parks notify you they wouldn't have someone?
Last Wednesday.
Okay, so plenty of time. All right, so we've earmarked this to be continued.
Yes,
I think-
I believe we scheduled it for April.
Okay. I think we can just
Okay.
deal with those items as they come up.
Yeah.
Okay. All right.
Okay. Any other
I'm sorry.
Any other agenda changes? Anybody have anything we know about?
All set in the agenda?
Yep.
Okay. Item number 2. Item number 2, approval of minutes from the Sunshine Ordinance Task Force February 6, 2019 meeting.
I have 2 changes here. On item number 4 and 5, you have animal lease requirements. I believe it was leash.
Leash. Okay.
Requirements.
Item number 4.
And it's in the motion for 4 and 5.
Typo. That could add a whole nother spin to that case, couldn't it?
Yeah, exactly. I'll go ahead and move the minutes as amended.
Okay. So
I'll
we take-
second.
Okay. Hang on a second.
Any other changes before we do that? Nope.
Ready
Okay.
for roll call?
Sure. Public comment on the minutes?
Public comment
On the minutes?
on the minutes?
Seeing none.
Take it by acclamation.
I think we can take that by acclamation. So moved.
No roll call?
No.
Okay, next item. Item number 3, file number 18079, complaint filed by Ellen Sang against Lily Magis and the Department of Building Inspection for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner. I believe the last time this case was heard, which was last month, February 6th, we left off at the discovery phase.
Okay.
You left off at the part. Oh, okay.
So, hold on. So did the complaint committee hear this and move it to us, or are you saying we're at a different point?
You're at a different, no. It went to complaint committee, then it went to the SOTF in February.
Okay.
So Ms. Sang stated that she needed more time to review documents that
correct.
came in 2 days before the hearing. And so Chair Wolf said, we will take it up at the point of discovery.
I remember that now.
Yes.
Okay.
Oh,
Goodness.
goodness.
Carbon copy. Well, hello. Hi there. What a sweetie.
Sorry I'm late, folks.
No worries.
Fine, Bruce.
So we just approved minutes. We're on the first item, and we're back to where we were when back at Discovery, because Ms. Sang said she needed more time to review the recent documents that she got. So that's where we're at.
Okay, we'll continue.
All right. Okay. Is Ms. Sang here? All right.
Yeah.
Well, we're not quite there yet. We're still talking.
I'm
but
confusing.
yeah,
Sorry.
yeah. Normally, yeah, we're kind of in between rebuttal and
Yeah.
the
All
right,
beginning
thank
part.
you.
Yeah. And just for the record, member Josh Wolf is also here.
Could someone
So just for a
recap
second,
this item?
go ahead. Yes. Who would like to recap this? It's coming back to me as we speak. But if I remember, Ms. Sang, you received some documents and you needed a little bit more time to review it. Why don't you go ahead and start and tell us where you're at with that? Sure, 3 minutes. And we'll give the other parties also 3 minutes.
Okay. It's starting. Okay.
Yeah.
Good evening. My name is Mr. Magis, the DBI failed to produce a single document the next day to my IDR. In October 18, I filed sunshine complaint. Not until February 2019, he emailed some six batches documents. She named the document in February. She also named the document 22, 36, 44, and 55 with redactions. But they do not have redactions except number 55. Number 55 has 2 emails from BOA, Board of Appeals. She altered both BOA's email by redacting the receiver's email address. Director of BOA informed me BOA is not required by code, nor did they redact any part of the documents. They are public record, anyone can download online. I download the BOA's document that she redacted. You can see no redaction on BOA original file. She redacted a receiver Greenwood's email address by claiming privacy. But BOA file not only disclosed his email address, but also his phone number address. She claimed the Sunshine allowed her to alter and redact the other agency BOA's public record, as long as she claimed involved privacy. All BOA's records are already public without redaction before she decided to alter and redact BOA's file. Her privacy claims are false and misleading. They have concealed and withheld a memo dated April 2nd, 2018 from DBI's plan checker hospital to Deputy Director Lowry. They conceal it from the public when the public is not the attorney. I obtained it from the attorney. Her document number 38 stated, Joe provide comments withholding correspondence you have with Rob. This document shall be produced even with redactions and the reasons for redactions. They continue withholding memo, staff comments, correspondence, and alter by redacting BOA's public record. Please find violations in order, Mr. Matches, DBI to produce all the records. Thank you. I want to show you, if you download, you can see. This is the BOA's, I highlighted this.
Just pull the microphone closer to you so we can continue to hear what you're saying.
Yeah.
Thank you.
This is from BOA. I highlight that, but it's no redactions. You can download that too. And then the information, they did redact the Greenwood.
Ms. Sang, is this, I'm just sorry to interrupt you, but is this documents that are already in our record?
No, this is not.
This is new documents?
Huh?
These are new documents?
This is they produced a redaction on recently.
Okay.
And then that's why I responded. And and then the number. I cannot see.
Continue.
But she submitted on number 38, batch 6, batch 4, and say that Joe provide comments withholding correspondence you have with Rob. That one you never produced to me or to you too. Thank you. If you want the date exactly, I have the date too. I just think that I might not have enough time. Thank you.
Respondent, would you like to approach? We'll give you 3 minutes to kind of bring us up to speed, so we'll have balanced time, and then we'll put it before the committee. So go ahead and tell us where you are with.
Sorry, good afternoon. Lily Magis, Department of Building Inspection. I respectfully disagree with Ms. Sang. We've produced documents to her as she requested. Just to recap, she sent us a request in August of last year. We responded duly. We produced documents to her. She asked us to narrow it down. There were 4 different types of requests. What we're focusing on right now is number 4. We had produced to her initially about 5,000 documents. Further narrowed it to 500 documents, and then over 100 documents. And then where we find ourselves today is at the 68 pieces of documents. The commission has received a copy of the 68 documents as was produced from February, so no additional production was made. Everything that Ms. Sang is talking about in terms of the documents, you guys have a copy of. As Ms. Sang mentioned, when we reproduce the documents to her, making it easy for her to review them. Batch number 4 requests for documents exchanged between staff. And so in order to answer her questions, we basically numbered the documents, 68, and that's why she mentions different numbered documents in reference to. So we have been in touch with Ms. Sang. We've been responding to her many different questions. I just want to clarify the redactions that were made. Our process is that as we go through production, we review documents and attachments. If there are attachments that require redactions in terms of a person's home address, if they say mailing address, we assume it's a home address, cell phone number, their name stays on the document. And from Ms. Sang, I do have copies of what was redacted, and we've informed her about 3 different times in February 22nd, 26th, March 4th, even today, to reiterate the fact that the redactions only reflect what we, as a policy for our department, to redact, which is private information. However, I did say to her that our apologies for number 55, which is as we use a redaction tool through PDF, Adobe, we mistakenly redacted, Mr. Greenwood's email, which he already has a copy of. Lastly, I just want to respond. She said that we withheld a document. The reference in terms of withholding was in reference to a different sunshine request that she had. It was not withheld for this particular request. And that withholding, it was withheld due to city attorney-client privilege.
Okay, thank you.
Thank you.
That's before the task force.
I have a question for DBI. I'm sorry, can you repeat your last name, please? Too?
Lily Magis.
Magis, thank you, Ms. Magis. What does your redaction policy explicitly say?
We don't necessarily have it written down, but as our process is that we redact for a person's home address, cell phone, and private email.
So you do that automatically, or do you do that at the request of the person?
No, we do that automatically as we look through our, it's part of our review process.
And for how is it that you come to feel that you have the ability or allowance to do that?
In terms of redaction? From my experience with redacting information, I also had asked for city attorney confirmation, and that private information was to be redacted, and we have the language for that.
Oh, but you don't have that language written down?
No, it's our practice.
Okay. All right. Thank you.
And we'd be happy to produce it if someone wanted to challenge that.
It's just that when departments that or agencies that do regular redactions, they usually have it written down, and when they because, part of being a respondent in this forum is we assume that everything that the complainant or the petitioner is bringing forward we start at 100%. They're 100% correct. Okay, because our view is that all information is public information that the city and county produces. It's the people's documents and information. So unless there's some law that restricts the release of that information, that's more or less your defense. And if you come without a defense, then it leaves us to believe that you don't have that authority to redact or withhold that information.
Can I respond to that?
Absolutely.
So we refer to the Good Government Guide, and in the Good Government Guide, it does state privacy information. So that is our policy. We don't necessarily have one that states like you do this in terms of redacting, but we use that as a reference.
Right, I understand. The Good Government Guide is not a citable law. It's a guide. Okay. It's created by a department that is not us. We don't follow it. We in fact, we disagree with some areas of interpretation in it. So what matters is what happens here. So this is kind of the way it kind of works. I mean, for instance, if a law enforcement agency were to be here and somebody was asked information about an investigation, they could cite various codes, police codes, penal codes, civil codes, stating why that information cannot be disclosed because it's under investigation, and the law allows for that information to be withheld while it's still under investigation. So it's kind of as crude a example as I can give.
Okay.
But that's, I would suggest that if you have a redaction policy, that it not just be something that everybody understands in the office.
Okay.
I would possibly suggest just to our members here is that maybe this is something that EOT needs to look into to see not only if this department, but maybe other departments that are regularly redacting if they have a written policy or not.
To the chair. Ms. Magis, on page 72 of the packet, in a letter emailed to Ms. Sang, you quote, we reiterate again, we do not redact DBI staff information. However, information from the public, et cetera, et cetera, et cetera, we are authorized to do under California Constitution, Article 1, Section 1, and Sections 6254K and 6254C. So it looks to me like that is your redaction policy that you're following.
Yes.
So maybe we can look at that more closely and see whether that's.
But it's not up to us to make their case for them. It's the respondent's responsibility to be able to
redact and justify.
To defend themselves based upon, especially with redactions and any withholding of information.
Mm-hmm.
The fact that you went and did the research on it on their behalf kind of speaks to my concern about it.
Well, it's just something that if they're telling this petitioner, they're telling all petitioners based on this, they're justifying. So
I understand that.
Yeah.
The
so
fact that the respondent didn't present that is concerning to me.
But it's in our packet.
I understand. So. Yeah. It's not part of it's not necessarily part of their defense. That's my concern about it.
Can I interject?
Sure.
I'm sorry, I probably misquoted when I said Good Government Guide. That is what we reference in our response to Ms. Sang. We've reiterated a number of times in our responses that we do redact only for that particular instance in terms of the California Constitution, Article 1, Section 1, and California Government Code sections 6254K and 6254C. We reference that in, whenever we when we redact information.
That's exactly why it's not incumbent upon us to do that.
Now that it is, could we ask the city attorney what he thinks about that policy they're following?
Our meeting.
Could you respond to that? So on page 72, they're quoting some I guess, California laws that they use to justify their redaction. I'm not saying that they're doing that correctly or they're following all the steps of justifying how they're doing it, but do you have any comment on that particular body of law there? I don't know if that's something you're familiar with off the top of your head.
Yeah, I don't know the exact provisions off the top of my head. I do know that there are provisions that allow for redaction of certain personal identifying information when responding to Public Records Act requests. I could look that up while this meeting is going on and maybe give you some citations. But there certainly is statutory basis for redacting that type of information.
Thanks.
Sure.
Yeah, that might be useful. Do you want me to carry on with this item? Okay. Member Wolf?
Last month, we talked a little bit about the changing technology world and the fact that most computers no longer have CD-ROMs and how large amounts of data such as this request can be handled in the event that a requester doesn't have a CD, or in this case, they may have had a CD, but they were not able to receive the information except for actually coming to City Hall. And so I asked some questions about that at the time. Did you get a chance to look into that and have any answers?
Yes, Commissioner. We looked into next requests, and that is something that we have made a change in our policy. If and when the files are too big that we can't email them, we'll go ahead and produce them through next requests.
Great, thanks.
Ms. Sang, I had a question for you as well. Okay, before you say that, just answer this question if you would. So I think at the end of last meeting, there was 68 documents that they had recently provided to you that you asked time to review.
Yeah. Sometimes you said 68, sometimes they said 69. So either way, it's okay.
Okay, so there was a batch of documents. So,
yes.
And correct me if I'm wrong, but it sounds like you've got those documents, but your issue is that some of them were, in your view, incorrectly redacted or not provided in full. Is that where we're at right now?
I mean, in my opinion, is that when you produce document, you don't redact somebody other departments. If you think that I redacted the file from DBI initially, their own department's file, I might understand why you're asking those questions. They are redacting somebody else's, other department's file. It's not their own. They already publicly publish. You can download that. You cannot say, "Oh, I don't like that." I know why do they do that, but I know it's not before you. Okay. And because actually, that one I don't know how to give to you, but this one they are redacted. One is not the private phone number, all those things. It's the email address.
Can you put it on the screen.
Focus it.
Cheryl, can you help her with the focus? There we go.
Okay. Now see, this is the email address. It's not phone number, all those things. Actually, those things are in the BOA's file. They have that. They don't redact that. And then also this one, the second one, they redacted. Actually, they have only 3 receiver's name. They redacted something as a blank.
So basically you're saying the DBI is using their redaction policy to redact everything they're sending you, even though it's not from their department. Is that?
Yeah, if you from your own department, I understand why you're coming that question. But they are you can redact it from somebody like the police department. You don't like it, and you redact it. That's not fair.
Let me ask you again, though. Now that you've had a chance to review the 68 or 69 documents, aside from the redactions, do you feel you have everything you've asked for at this point with this complaint, with this particular complaint? Yes.
This complaint actually is between the DBI staff, including directors. Okay. But this one, the memo, they withheld that, they concealed it, they never produced. I get it from my attorney. So if I cannot get the attorney, then this will be forever concealed. They all have to do is, nicely, we produce her anything. But this is, your public record keeping. You should have this memo. But I have been asking during this time, less than 1 year, but they did not produce. They did not even mention the 9L. Why do they hold that? So you don't know a lawyer, then you don't get this document. And then second thing is this one, they says, here, they said, Joe, provide comments, withholding correspondence they have with Rob. Then this is the documents. If you redact it, you still have to produce. You redact it, and then cite it why we redact it. But they did not. They completely. I like to see why you can find the record. I would like to know. And then they have been saying that like they produce all the things. They says number 22, 34, 44, 36, 44 have reductions. Until today, I don't find those documents. I asked him in email recently. I says, hey, please either produce the page with the reduction or tell me how to find them with the reduction. She refused to respond.
Okay, thank you. Ms. Magis, would you approach, please? Yeah. Go ahead. So to respond to those particular.
Why don't you do that first?
Okay. Just to those particular pages he referenced, because you led us to believe that the 68 documents are in our package or have been sent to us as a copy as well. And I appreciate this is a lot of material, and I'm glad we have it numbered at least, but I think it was number 22, number 44, 36. So she's saying that that not only she's not seeing the document, she's not even seeing the redacted document for those instances. If you could respond to that directly.
So in our emails to her, the last 3 times, we've informed her and also actually provided her, we highlight the header of the email as we state the number of the document, and we state in this case, this file that's highlighted, you click on that and you find the redacted document within that file. So we've informed Ms. Sang this 3 times already. We sent her
Down a little bit.
I'm sorry. I just wanted to show you, this is an example. I thought I printed out the whole entire email that we sent her today. I was not,
Yeah,
I
can you
did
just
not do
move
that. But this is an example.
Just move the page down so we can read it a little
Oh,
bit lower
sorry.
down. Yeah, the other way.
So in this case, this is
I see. Okay.
number 44. We state, sorry, I
You
can't
have to
really
click
read
the
it.
link to find the redacted document is what you're
Correct. And then you click on that and the within the file is redacted. I brought a copy of that so I can show you what that looks like.
saying. All right.
As you'll see, we reiterate again, redactions are found in the attachment of the email below. We redacted personal information from the public. Click the PDF link to open the files labeled RMD files. And then in there, I wrote page 2 and page 6. I'm sorry. Hold on for a second. I'm sorry, I have the wrong file. This is page 2. The redaction is in black. This is page 6. The redaction is in black. And we did that with also the other documents that we produced to Ms. Sang. Page 14, redactions in black. Same copy. This is the BOA, and the redactions are in black.
I have a question on that. Can you put that back up, please? So, it should automatically. It's not.
Self-focus, is that what it does?
Self-focus isn't work. So the area that you redacted, the information with regard, as far as their the address and the city and the state and all that, but you didn't redact their name.
I was told that name is public.
name is public, but address is not public?
Correct, or
But
their
at the top of the
personal cell phone or their
Right.
personal email.
Right, but at the top of the page, you didn't redact Ms. Tsang's information.
That's because we're producing it to Ms. Sang. If we were producing to someone else that that didn't ask for her information, we would redact her
So if it was the reverse, if the permit holder...
Correct. We would redact her personal information except her name.
Okay. So you it sounded like you changed your testimony with regards to the reasons why you redacted, under what these statutes, California Constitution Article 1, Section 1, and California Government Code Section 6254K and 6254C. Those are your reasons for that gives you the allowance for redaction?
Correct.
Okay. So can you tell me why those codes give you that ability?
Based on what we've read through the section, the Good Government Guide, and also in past experience, is that we're allowed to redact only for private information, email, cell phone, home. If it's not business, if there's a question, we redact because it's just more. We err on the privacy matter. Mm-hmm. If we do get challenged, then we will produce and work with the requester on that.
So you will reveal the information if there's if somebody quote unquote appeals.
Correct, or we're compelled to.
Okay. So I just want to go over what these particular sections that you're citing for this, because I'm not quite following for this particular kind of information that these particular statutes apply. So let's start with 6254C. It's one line, very short. Personnel, so it says, except as provided in section 6254.7 or 6254.13, this chapter does not require the disclosure of any of the following records. Subparagraph C, personnel, medical, or similar files, the disclosure of which would constitute an unwarranted invasion of personal privacy. So that doesn't seem to apply here. Section K, G-H-I-K, records, the disclosure of which is exempted or prohibited pursuant to federal or state law, including but not limited to provisions of the evidence code relating to privilege. So does this document speak to any of that? Is there any other federal or state law that prohibits the exposure or the disclosure of a permit holder's address?
I'm not sure.
Okay. Are there any provisions in the evidence code that would provide you privilege for redacting or withholding a person's permit holder's address?
I'm not sure.
Okay. And then let's go to the California Constitution. In Article 1, Section 1, it's, again, it's two sentences. And this is the very beginning of our state constitution. All people are by nature free and independent and have inalienable rights. Among these are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. And privacy is expanded in a lot of different ways throughout the entire Constitution and in the codes that are related to it. I think you'd have to be a little more specific as to what provisions allow this particular kind of information for the permit holder's privacy in that way. I mean, sometimes people will come to us and say, well, this person has had a temporary restraining order because from the other party, and so we don't want to reveal their address because they had to move or what have you. Okay, fine. There's there are some codes that allow for such things. But just of general nature, based upon what you are testifying as your defense for withholding or redacting this particular information, I don't see any.
I also want to state that within our response, which I didn't completely read, it says, see also California Government Code Section 6250 and Section 67.1G of the San Francisco Sunshine Ordinance, SF Admin Code 67.1G, legislative findings on the right of individuals to privacy.
Where are you reading this from?
This is our response to Ms. Sang also as part of her, as part of our response.
You know what page it's on in the package?
It was our initial response to her on August 20, actually not initial, it was our response to her on August 27th, which was a response to her initial requests. We've said it from the beginning and throughout the request.
While we're looking that up, Ms. Magis, just a quick question.
Sure.
Did someone in your department give you these codes to slap onto letters or responses? Is this your own research? Where are you getting this from? Where is this policy?
This is from, if I remember, I think from the Good Government Guide.
So you personally went and researched this, pulled this stuff out of the Good Government Guide, and you add it to your responses to people asking for information? Or did this come from somewhere else?
We got it from the Good Government Guide. We put it together.
Who's we?
My colleague and I, in terms of putting it together. I had.
Who's your colleague?
Carolyn Jayan.
And her title, what's her position there at DBI?
She's an executive assistant, but basically the information came from me in terms of me compiling it as I read through the document.
Okay.
And
how long have you been in the position as communications director at DBI?
4 years.
4 years. And when you came in, did you not inherit, this kind of stuff from your predecessor? I'm just trying to get to the root of what policy your department's following, because as Chair Wolf said, ultimately I think this might go to EOT just for some refocusing, because we're kind of getting into areas here that are a little bit, past the scope of this. But I'm trying to work out where this ball started. And if you're saying it's purely your work,
yes,
it is. Okay, that's fine.
So if I can follow up on that a little bit. Based upon the codes that you have now added, 6250 of the California Government Code says, in its one sentence, in enacting this chapter, the legislature, mindful of the right of individuals to privacy, finds and declares that access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in the state. That's not a protection for privacy. That is the opposite. And 67.1G says private entities and individuals and employees and officials of the city and county of San Francisco have rights to privacy that must be respected. However, when a person or entity is before a public body or passive meeting body, that person and the public has the right to open and public process. Again, I don't know how these two sections apply to redaction. It's the opposite.
Okay.
A permit holder is not a member of the city and county family, as far as the government is concerned. They're a member of the public, and the public has a right to know.
Okay.
So I guess my question is will you unredact those items and deliver them to?
Sure.
Okay.
Any other members? Should we move to rebuttals? Since we haven't officially had that. Sure, you'll get a chance for rebuttals. So, Ms. Magis, I think you rebut first. You have 3 minutes for rebuttals if you have anything else to add.
I just wanted to reiterate that we've been working with Ms. Sang, and we continue to want to respond to her requests. I think that we've been very accommodating to answer her different questions. I realize we may have I'm going to recognize made some mistakes, but at the same time, we are happy to produce the documents. We are happy to produce any documents that Ms. Sang would like in our possession, as long as we have it and it is responsive. Thank you.
Thank you. Ms. Sang, you have a chance to rebut. You have up to 3 minutes.
To me, this is the amazing. If you allow them to redact somebody else's document, it's already public record. And also, if you go to DBI, they have the same director, same deputy director, I guess, the same attorney advised them. If you go to 4th floor, called the record management, you can get all those without any reductions. You can even make copies, 10 cents a copy. Actually, I made one. I didn't know that she would say that way. I actually didn't see that. It's very difficult for me as an old man. I never learned in school how to open those kind of things. I wasn't able to do that. Actually, I asked them, would you please produce a copy to me? She refused. So until today, I saw this. But this is a public record already in their own department. If you go to talk to the city, inspector, if they have they give to you. Some of them not even charge you 10 cents, but this is public record. You know, you are permit holder. All those information, including his the team, so for the engineer, those should be public record because they're asking for your name and company's name and address. All those things that you affecting somebody else's property when you build something new. Okay, this is actually what we're talking about before you is public record. They are public record. It's not up to her to say that, I want to use my power or position to redact something because I just don't like Ms. Sang. I'm just giving an example. I know why do they do that, but that's not before you. But still, if you go to their own department, can get those all information without redaction, what she is saying is false and misleading, and then read along to say that she thinks she have right above BOA to redact BOA's file. This is just, to me, is unbelievable if you accept that kind of behavior. And then they says, Joe provide comments. Where's the comments? Where's the email between them and with the Rob? Even you redact it, you still have to produce according. I believe that's the Sunshine Law. You can redact it. You don't let me to know what are they talking about, but you have to prove it that some document exists. And then the comment is never produced. I appreciate that they said that they tried to give me what we want behind you. I hope they have the same attitude. Thank you.
Thank you.
I have a just clarification for each of the parties,
Sure, Wolf.
if you don't mind. Ms. Sang, I have a question for you. Did you happen the BOA documents? Did you happen to get those documents unredacted?
When I go to the 4th floor, I saw those documents unredacted. I make one copy, okay, for the application, okay.
So you were able to see it and make a copy?
If I request it, but this is not for this one. Actually, it's for any application. Except the plan, and that you have to get the owner's
permission. So you're
permission.
just saying in general,
yes.
If you went to BOA and you were to ask for the same document, from a different person, in general, any document on the same form, it would be unredacted?
I have seen on the 4th floor, the management, if you go there, that's not redacted. But you Sunshine, we don't have to go to 4th floor to see documents.
No, it's not my question. I'm just focusing on what because I'm going to ask Ms. Magis another question. I'm just trying to clarify if you were able to see this same document or now other similar documents that are just like this, where there's a requester and a permit holder if those documents were redacted or not.
In the 4th floor, what do you call record management? You can see all the records.
Okay. Very good.
Not necessarily this one. And then the inspector I talked to a long time ago. Okay, she give a copy to you, and then without redaction, and then I'm not talking about this particular request.
That's fine. No, I understand
So
that. But
I'm
it's,
asking-
whether it's this document or the same exact document for any number of other people, that's all I'm concerned
Yeah,
about.
yeah,
So thank you very much.
Okay, thank you.
Ms. Magis? Ms. Magis, I'm just wondering, so that was another question I wanted to ask, just to reference. This document that was redacted for the permit holder was not your document, correct? It was a BOA document? Was that the one on page 72?
Which item is this, 44?
Correct. Oh, I'm sorry, not 44. Number 36.
Can you shrink that a little bit so we can see the whole page?
Okay, so it obviously at the top it says Board of Appeals.
Correct.
So is this the document that you redacted or that your department had redacted? Yes. Was it that your department redacted it or did Board of Appeals redact
We
it?
redacted it.
Okay, is that a common practice for you folks? Redact other departments' unredacted documents?
I realize in this instance that is the case. I'm not sure if we do. I just want to reiterate, the goal is not to redact just to redact. We were trying to follow our best practice, and if it seems like we don't redact this, and I realize this is BOA, not realizing BOA is a public document, we wouldn't redact it.
All right, thank you very much. I just wanted that clarification. Thank you.
Thank you.
Back to you.
Okay. Any motions being entertained? Robin?
Member Highland, I think you were recommending or entertaining sending it to another committee at this stage.
To EOT, I think just as a postscript, but I think having got to the meat of this, I'm definitely sensing a couple of violations. I don't know if anyone would like to 6721 and 67205 come to mind. I think those are originally noted by Nick Cola on the city memos, both for immediacy and timeliness. I can make that motion then to find violations of 6721 and 6725.
Can we narrow it down to a specific section of 6721? Because I don't think it's the entirety.
I'm open to that. We're still fleshing out the original motion. Hold on. I mean, there was some volume here. They did respond in stages, but I think still.
So it looks like it's 6721E. Yeah, 6721E, and you were suggesting 6725?
A. Because ultimately it was the unnecessary redactions that slowed down the process somewhat, I think. So let me restate the motion, 6721E and 6725A.
So I'll second that motion.
Okay.
See what everybody else thinks.
Take public comment on that motion. Seeing no members of the public, take a roll call.
I would also ask that this be referred to EOT to review their redaction policy, make sure it's in writing, and make sure it's correct.
That's what I was going to suggest. I also wanted to ask Ms. Magis to continue working with Ms. Sang and provide her, because it didn't seem to be too much volume. Instead of giving her, the PDF links, please print those out unredacted and email those to her as well. Member Wolf?
As far as EOT reviewing the redactions, I am a little perplexed how to incorporate section 16130 in regards to the larger story, so some advice there would be helpful.
I don't think we're asking for you to review the redactions themselves, but their redaction policy.
No, I understand that. I'm saying that Section 16.130 is outside the purview of the Sunshine the Sunshine Task Force.
What's Section 16?
It's Proposition B that specifically states stuff that does correlate here, so I'm a little confused how best to...
Oh, interesting. So that generally focuses... Prop B was specifically focused on city contractors and their ability to, in the course of their work, to collect information beyond the scope of what they were contracted for.
That's the primary thing, but as I read it, it also extends to how our city agencies maintain the private individual information of citizens as well. I haven't read through it line by line recently, but...
That's true. I think as a broad outline, that this, just as a broad outline, the city does have a lot of people's personal information for various things. The purpose of Prop B was to protect people's information from city contractors from collecting more than what they're contracted for and from sharing it with third parties or using it in unscrupulous ways. It wasn't to prevent members of the public from access to public records.
Yeah, I haven't thoroughly reviewed it, but that is where the conflict that I'm starting to see in there is. And just, this is really in regards to reviewing their redaction policy as EOT, not your motion itself. But I do have some concerns about pursuing that without better clarification.
Well, I was going to say, I think what you can do is, I think we still need to review their redaction policy, whatever it is, and kind of get an official read on that and your interpretations. But I think if you're sensing a conflict of what you're talking about in Prop B, that might be a separate item that can come back before the whole task force for discussion. That might be once you've kind of got into a little bit more.
Sure.
I'll take the bait on that one, and I will say this: we haven't gotten a full analysis of how Prop B affects the Sunshine Ordinance with regards to how it's the way it operates, the way Prop B is meant, the privacy first policy essentially, or ordinance is meant to operate. So we don't have an analysis of that. I would go as far because it could, there could be some conflicts with regards to the Sunshine Ordinance, and I would say if there is enough of a concern, I would be willing to put this with the makers also agreement to put this motion on hold to find out that information. I mean, it benefits everybody beyond just this case.
The way that I read all of these pieces, and perhaps our city attorney can weigh in because this is outside of my zone, is that Prop B is not actually within our purview as the task force. However, the language in 16.130 of the city code seems to, although it wasn't addressed by the respondent, appears to be an argument around the redactions. And so as far as I don't think there's an issue with the motion that's before us, but I do see a difficulty navigating how to analyze their redaction policy as EOT in light of the conflict between the Sunshine Ordinance and Section 16.130.
Well, I guess I'm a little. I guess my concern about that is not whether we have jurisdiction over the Privacy First Ordinance, but whether it has any effect on the Sunshine Ordinance. If it has some superseding, something superseding bearing on it that we are not aware of yet, that's something that needs to be examined.
Yeah,
and it doesn't matter whether we speak to it or not. The question is whether does it affect the Sunshine Ordinance, and the Sunshine Ordinance equally was passed by the voters, except that Prop B was a constitutional amendment. It's a charter amendment, which could possibly supersede the ordinance.
I think based on current information, I'm happy with the motion as is. I think this is certainly something we need to flesh out more with our president attorneys, city attorney, etc. But
so then let's just extend. Let's move this. I'd say let's move this to a vote. Refer it to EOT. Have EOT confer with our legal counsel.
Well, that's the thing, is that because EOT doesn't have legal counsel there, that's the reason that I am hesitant to address this at EOT.
So ask for it now so that you'll have it delivered to you later.
yeah, you can do it in writing.
Yeah. You could always request it in writing so it could be done in time for or you can request it now, and I'm sure DCA Price Wolf will make a notation of it. And
sure. Can we make a request for an analysis of how Section 16.130 / Proposition B from 2018 intersects with the issues relating to redaction as they relate to this case?
Or Sunshine Law.
Does that give you enough information to know what to research, and would you be able to do so, or?
Into the mic. Yes.
Yeah, certainly happy to look into it.
Great.
See what we can come back with.
Awesome. Thank you.
Okay. Do we need to? Are we adding that to the end of the motion, or is that a?
yeah, I would add that.
Okay. So as amended. Second.
Yes.
Yes. Okay. All right. So. Yes. Let's take public comment on that motion since it changed. Again, seeing no public comment, we'll take a roll call.
Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Hinsey, aye. The motion passes.
Thank you. Just remember, remind Ms. Magis to please provide those PDF documents unredacted to Ms. Sang by email. And if you do that within 5 working days, that would be great. Okay. Thank you.
Please call the next item.
Before you arrived, Chair Wolf, I informed the committee that Betty Mackey emailed me today at about 11:30 this morning that she had a conflict and would be unavailable to attend today for the hearing. However, Mr. Beck is here. He's the respondent. And I said it would be up to the committee to decide whether to hear him or not.
And you said something also about a proxy, right?
She asked if she could send a proxy, and I told her that our policy is that she has to send a letter signed by her saying that someone would represent her, and as of 2:33 o'clock today, I didn't get anything.
Okay, thank you. We're just beyond our time for general public comment, so let's do that now. Can you call item number 5, please?
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Is there any general public comment?
Good afternoon, task force members. I'm still Richard Nee. After all these years, a couple of items that I'd like to bring to your attention that could affect sunshine in San Francisco and throughout California. Number one, last year, the legislature passed and Governor Brown signed Senate Bill 1421, which basically opens up to the public scrutiny police misconduct, discipline, and use of deadly force investigations. The San Francisco Police Officers Association is taking that to court, and I would think that this would be of interest to you. Second, there is a bill recently introduced for the current session, Senate Bill 615. The author is Senator Ben Hueso from San Diego. Senate Bill 615 would create additional delays for people wanting to file lawsuits to get public records to which they are legally entitled. The California News Publishers Association is adamantly opposing this. I imagine there are, not long from now, other government transparency advocacy organizations will do the same. Basically, it would do two things. It would require that people wanting to sue for public records first have meet and confer sessions, documentable meet and confer sessions with their respondent agencies. Second, it would shift to requesters the burden of proof. If a case does go to court and is adjudicated in particularly in favor of the requester would be required to prove that he or she should not have to foot the legal bill for this. So again, this is something that I think you would want to watch. Basically, what it will do is the whole thing sends a message to public agencies saying that chances are they can violate the Public Records Act, or in our case, the Sunshine Ordinance, and skate on it. Something you want to watch. Last but not least, something you might already know about. On Thursday, March 14th, the Society of Professional Journalists NorCal chapter will have its annual James Madison Awards dinner honoring champions of sunshine and the First Amendment. Hope you can be there. spjnorcal.org for information.
Good afternoon again, Peter Alexander Cherneff. And I just wanted to share some other concerns that I think might fall into the purview of some of your scope of what you do, and I hope it does. And one of them is my concerns that have been dealt with by Tony Serra, the famous California, San Francisco pot-smoking lawyer, has been featured in films and has handled some very serious cases. Not only did he complain publicly that Shrimp Boy Chow was not properly adjudicated. As a matter of fact, dealt with a corrupt situation, which is accurate because it is well known that he was innocent, so too Senator Lee Lanier. But I want to bring to your attention the fact that as this man is wearing this Constitution sweatshirt, that the fully informed jury and the jury nullification right and act is being denied and quashed by the judge in the very current Monsanto case. He has belittled the jury. He's basically called them stupid because they have to, he said that's why they're dividing this trial up into 2 or 3 parts. They're being intimidated, and these people are not aware of the fully informed jury and jury nullification. And so I believe that as long as it's taken to get someone like Monsanto into court, now that the Bar Association is stepping in to protect Monsanto by undermining the jury's capacity and their strength by deception, denial, and what's that called? Intimidation. The same thing is actually going on once again with Tony Serra in the East Bay with the Oakland case, the ghost ship case. And I want to bring to your attention that I provided law enforcement and the media and others information regarding one Peter Larson of Prawn Investments. He has investment companies in Los Angeles, New York, and San Francisco. And over the last 45 years, what he does is he purchases old buildings, tears them down, and then builds really expensive places. He has the cohorts that are in the Church of Scientology, which also operate in providing the arsonists that have burned down approximately 38 buildings in the last 45 years in these 3 cities. And so this man has also collected the insurance and on 7 demised wives over the last 40 years. That somehow this man never gets any attention. He seems to be above the law, and the facts of what I state are hard to find, but yet they exist. And so I would hope that you would put attention, if you can in any way, to let the juries know that they have this fully informed jury information and the jury nullification, because what these judges are doing is flat out treasonous and corrupt. And I submit this to you as fact, and as I said before, the Bar Association has usurped the 3 branches of government, which is a treasonous coup. Thank you for your time.
Is there any other general public comment? Seeing none, public comment is closed. Please call the next item. So we're back to item number 4.
Through the chair.
Read it.
I had a question for the clerk. You mentioned our policy states that they have to send a signed letter. Is that really what we have, or would an email not suffice saying that they designate so-and-so to act in their...
Victor specifically said a letter signed. He said that, and I wrote that to her, that she would have to send a signed letter.
Yeah, that's our general practice.
It's got to be that.
I'm just curious, is the person who she designated as her proxy here by any chance?
Is there somebody here representing Betty Mackey?
No?
No, okay.
Okay. Great. Okay, thank you. Okay, so members, for item number 4, we are missing the petitioner who cannot make it. She hasn't requested a continuance?
No, she just... Pardon. She didn't say anything about a continuance. She just said, I can't make it today. I have a conflict. This all took place within about an hour between like 10 o'clock and 11 o'clock this morning. So I didn't know if she was rushed or what.
Okay, I'm not going to try to interpret what her intention is here. So, but the respondent from TIDA, is that person here? Okay, great. So members, how should we dispense with this? Member Josh Wolf.
I'm a little confused why on the agenda it seems to be the one item that doesn't click to bring up the additional items. Is that...
If you click on attachment 1 and attachment 2, it'll come up.
Got it. Thanks.
The volume of records was larger than I could scan and attach to the particular item number, so we had to split it into 2.
Great, thanks.
Yeah, in the future, if we can put a little notation, click here, because
it activates.
Yeah, but when I bring it up on a web browser, there's nothing that highlights.
Yeah,
It depends on what you're using. I saw it, but
Usually it's the bold text that is clickable, and so I was looking for bold text and had no idea that those
I think
were
what
the
we ended up doing was highlighting part 1 and highlighting part 2 as separate.
Yeah, it doesn't
It
show.
doesn't
It only
show
shows
that?
up because you're. Yeah, it shows up as italics, but not the highlight in yellow. I guess it would be right if you open it up.
Highlight it in yellow next time?
No, well, we'll talk about it later, but I
Yeah.
just want to notate that even for the public, that could be a little kind of cryptic, like where do you go to click to? So
Okay.
let's.
Well, we tried to be careful.
That's okay. We'll figure it out later. It's just a operational thing. We'll figure it out. Okay, so back to our issue here. Yes.
So my feeling is if the respondent wants to hear it and we agree to hear it, I feel that we should hear it to a conclusion. If we hear it, the one side, and then decide that we're going to continue it to hear from the complainant, I would be against that. Continuing the case, just like our first item today, it was really hard to pick up where we left off and things like that. So if we make a decision that we're going to hear it, I think we should hear it and come to some conclusion today that's not a continuance.
Member Josh Wolf.
I'm not sure who from EOTC from back then is still with us. I did not see the attachment, so I don't feel prepared to summarize the case myself. Although the complainant didn't specifically ask for a continuance, she did inform us she wasn't going to be here. It sounds like we didn't specifically ask if they wanted a continuance either, whether it was for the back and forth or whatnot. So I would feel more comfortable continuing this item over hearing it with with the respondent but not the complainant, and especially given that I have not reviewed the information to summarize better what happened at EOTC.
Yeah, and that there was a problem. And that there was a problem with the agenda, and it might have been difficult for some of us to access the materials.
Okay. The concern that I would have is if the outcome. I'm okay with moving forward with it if there's enough information and it goes the way it goes because the petitioner is not here, and for whatever reason didn't request a continuance. If we feel in the best interest of the public, because that's where we provide most of our weight, that we want to continue it, we can do that. It's up to you how you want to proceed. We could either start it going, and then at a certain point, if you feel like you want to continue it, we can do that, or we can just continue it right from the jump here.
I'll make a motion to continue it.
I'll second.
So moved by Member Kanata, second by Member Hinsey. Is there any more discussion on this, members? Any public comment on the motion to continue? Seeing no public comment. Okay. Can we take this by acclamation?
So you moved it?
Mm-hmm.
I just want we don't have to necessarily do a roll call on it because it's we're not making a decision on statutes, so it's purely operational. If we take this by acclamation, are there any objections? Seeing no objections, the motion is approved unanimously. Thank you, respondent from TIDA, for your time. And we'll let you know when it'll be scheduled next. Thank you, and apologies. Okay, let's call the next item.
Item number 6, file number 18086, complaint filed by Mark Sullivan against the Mission Dolores Green Benefit District Formation Committee for allegedly violating Administrative Code Section 6714 by failing to allow video and audio recording, filming, excuse me, and still photography of a policy body.
Okay, are both parties here?
So,
okay, great.
so this was at compliance and amendments.
Go for it.
And we didn't think that we had jurisdiction on this because this is a formation committee. There is no official green benefits district. There are neighbors meeting, going through the process to determine how to form one if they want to form one. similar to the green benefits districts. They're somewhat similar to the community benefits district in where property owners get taxed extra money, and that extra money is used for a benefit purpose. So we didn't think we had jurisdiction because there is no green benefits district yet. There is no city agency.
If I could just add to that, and again, this is pretty from memory, there was some correspondence with the city about this body setting themselves up, but they weren't there yet.
Correct. And generally, when any of these benefits are set up, you do work with the city because the city, it's advantageous for the city to have these districts because it definitely benefits a green area or a commercial area.
Even though they did have some influence on funds, they didn't. I seem to remember that. It was interesting.
Yeah, generally these districts, the funds come from the taxation.
Mm-hmm. Yeah, as I remember, they hadn't received the funds, but they had some influence of how the funds were spent in that.
Okay, so let's reserve this back and forth discussion. Thank you for the brief on that. Let's bring up the petitioner, Mr. Sullivan. You'll have 5 minutes for your opening testimony.
Good afternoon. The main purpose of my complaint is to get a judgment as to if and when the Sunshine Ordinance applies to Green Benefit District formation committees and any future construction of private government bodies or the privatizations of parts of government. The complaint filed as far as the videotaping is easily proved by looking at the videotape. In the Sunshine Ordinance under 67.3 definitions, D, policy body shall mean any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors. Policy means decisions made for or on a group of people. A group of citizens can put forward a petition without making policy until the vote is final. Under Ordinance 14-14, Article 15A, and state laws, benefit district formation committees make policy decisions before the vote on their petition. They decide who can vote on their petition by drawing the lines of their district and gerrymandering their district. They decide the weight of each vote each property owner has prior to the petition and the final ballot by formulating the assessment each property owner will pay. They decide how long the petition drive can last. These powers to make these policy decisions come from Ordinance 14-14, Article 15A, and the state laws that it is based on. This petitioning and voting process is not the norm in that policy decisions are being made by a group of citizens before the actual petition and final vote stages. If you do not call the determining of who can vote on your petition, how much weight each voter will have on your petition, or how long your petition drive can go, policies, then what do you call it? In regard to the question of creation of a policy body in the clause, any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors, I interpret this clause to mean that it is the ordinance or resolution that creates the board, commission, committee, or other body. The use of the Board of Supervisors stipulates to the origin of the ordinance or resolution, but does not mean that the Board of Supervisor actively assembles or names a body created by the ordinance that they have passed. Committees or other bodies that actively pursue the goals of the ordinance are a creation of that ordinance. Using this interpretation, city government, city departments, and SF citizens can create committees and other bodies in having powers given by the ordinance to make policy decisions in the pursuit of the goals of the ordinance. As to Green Benefit District committees, they would not exist if not for Article 15A. The Green Benefit District goals and the process and powers given to the formation committees come from Article 15A, Ordinance 14-14 of the Board of Supervisors. Article 15A has a couple of points where anybody establishing a Green Benefit District must go through the Board of Supervisors. The first of which is under definitions, page 2 of Article 15A. B, petitions notwithstanding California Street and Highway Code Section 36621A or any other provision of the state law to the contrary, the Board of Supervisors may initiate proceedings to establish a property and business improvement district upon receipt of petitions signed by property owners in the proposed district, who will pay at least 30% of the assessments proposed to be levied. After a Green Benefit District Formation Committee has made policy decisions like which property owners will be in the Green Benefit District, their assessment, the Green Benefit District's board's composition, and how the board is elected in the Green Benefit District's management plan, the BOS may decide to initiate proceedings to form a Green Benefit District. The GBD formation plan, with a weighted petition of 30% of property owners, advises the BOS to initiate proceedings early in the process and before a Green Benefit District is constituted. The Formation Committee can be seen as an advisory body, could also be seen as an advisory body that would also be covered under the Sunshine Ordinance under 67.3 definitions D4. On behalf of Public Works, the City Attorney's Office reviews and makes suggested changes to the draft management plan and engineering report before the petition drive to make sure they are okay for the BOS after the petition. It is during the policy decisions and creation of the management plan that the Sunshine is most needed. After a Green Benefit District is established and many important hard-to-change policy decisions have been made, Sunshine after is not open government. The fact that the BOS has passed Article 15A and needs to have some sort of committee to reach the goals of Article 15A to establish a Green Benefit District should be enough to have the Formation Committee covered under the Sunshine Ordinance as another body. The BOS, the City Attorney's Office, and the Department of Public Works, and now the Office of Economic Workforce and Development all participate in the formation of Green Benefit Districts. Specifically to the Mission Dolores Green Benefit District Committee, San Francisco Park Alliance and their Place Labs have been awarded a $156,984 grant to explore the level of support for formation of two Green Benefit Districts, Buena Vista and Dolores Park, which is the Mission Dolores. Of the $156,984, $131,000.
Yeah, okay, please wrap it up. You're beyond.
Okay. My thing is, I do not think it was the intention of the BOS in passing Article 15A to hide anything. I just think the Sunshine Ordinance must catch up to the evolution of government.
Thank you. Are there any persons or witnesses on behalf of the petitioner or the complainant to provide any additional facts or evidence? Please come forward. Please state your name for the record.
Thank you, Mr. Chairman and members of the task force, for this opportunity and for your important work. My name is John Hooper, and I live in the Haight-Ashbury, where an unsuccessful attempt to form a Green Benefit District was held last year and was overwhelmingly defeated by our neighborhood. What I'd like to add to what Mr. Sullivan said is that this program is not a bunch of neighbors getting together informally. This is a city-instigated program. It's city-funded. There's a full-time Department of Public Works employee who spends his entire time as Green Benefit District program director. One of the chief assistants of the Office of Workforce and Economic Development is intimately involved in every aspect of Green Benefit District development, from the formation of the organizing committees. The funding is completely from the city, and it seems to me that when this whole idea was initiated, there was no associated mechanism for oversight. So, for example, at public meetings, to help form these Green Benefit Districts, no minutes are taken. No record of the proceedings is available. Websites are frequently changed. And we therefore, in the absence of any other government oversight over this process, we really look to you on the Sunshine Ordinance Task Force to provide some level of scrutiny to this program, which is really out of control. I'm going to, with your permission, I'll submit some remarks for the record, and I'm also going to submit a recent Public Records Act request that I submitted to various city agencies, and I submit that just for the purpose of showing you how little you can obtain without resorting to Public Records Act requests. This is the opposite of open government. This is a closed process. It's very hard to penetrate it, and it desperately needs oversight, and we hope that you will undertake this exercise. Thank you very much.
Thank you. Are there any other persons or witnesses to provide any facts or evidence on behalf of the petitioner or the complainant? Please come forward. State your name for the record.
My name is Roger Hoffman. The question before you is, does the Sunshine Ordinance Task Force have jurisdiction in this case? Per the city attorney, you have jurisdiction over passive meeting bodies defined as follows in section 67.3C1 of the Sunshine Ordinance. Advisory committees, not policy bodies, but advisory committees created by the initiative of a member of a policy body, the mayor, or a department head. That's sufficient for you to have jurisdiction. The complaint demonstrates that the initiative for creating the Mission Dolores Green Benefit District Formation Committee came from the Department of Public Works, with support from its director, Mr. Nuru, and funding for the committee came from DPW. Now, Mr. McHugh, in the prior meeting, testified that his neighborhood committee received $11,000 from former Supervisor Sheehy. What was not brought forward was that the consultant who stage manages the process received a grant from the city. The amount that they received should be examined by your committee and taken into consideration. So my belief is the Mission Dolores Green Benefit Committee satisfies the conditions of 67.3C1. It's an advisory committee. It's created by the initiative of a department head. That's all it needs for you to have jurisdiction in this case. Also, for your information, the problem of videotaping has been solved, or video has been solved, because they're not holding public meetings anymore. Their last public meeting was in November, and so by not holding public meetings, problem solved. Thank you very much.
Thank you. Are there any additional persons or witnesses to provide any facts or evidence on behalf of the petitioner or the complainant? Okay, seeing none, let's have the respondent, the Mission Dolores Benefit District Formation Committee. Please state your name and your position for the record.
Hi, can you hear me okay? Yeah. Things a little loose. Hi, I'm Conan McHugh. I'm with the Mission Dolores Green Benefit District Formation Committee. Really, I'm of Guerrero and 20th. We're a group of neighbors and local business owners that care about our community and are motivated to make a difference. In this particular case, we believe that the Sunshine Ordinance does not apply to our current situation outside any communication we may have with policy bodies or passive bodies, aka the city officials with which we may be communicating. The other point I'd like to make is we do believe that by applying this rule in our situation, you run the very real risk of setting a precedent that discourages community involvement. With me tonight, I have Jim Chappelle. He'll probably comment here in a minute. But Jim and my colleagues are again, simply local residents and business owners that were motivated to start making changes. I think each of us has a different story of what brought us together. Mine was talking to Hans, another neighbor in the dog park, about the trash situation we were facing on our street. Others were motivated by the shooting that happened in Dolores Park and wanted to see what we could do. There was a big community meeting with a couple of the supervisors after that And so we've been talking about all the different ways that we could take action to help improve our neighborhood. The types of things that we've been talking about have been all the way from lobbying our local supervisors to working with the mayor's Fix-It team. I've been on a couple of meetings since they're coming to the neighborhood now, using the 311 app. And we also decided that we shouldn't stop without the exploration of a green benefit district. That was mentioned by Mr. Kanata. Green benefit district is much like a commercial benefit district, with the caveat that the services can be used for both residential and commercial services. And I think that's an important one, because what we really risk doing here is that if just by getting injected and applying a heavy scrutiny before we've come up with an idea and started to form, you really are going to discourage people from donating their time to do that. We feel that we're not currently a policy body or a passive body. To the point that was made earlier, we feel that we haven't been created by the initiative of a policy body or passive body, else we'd already exist. And we would be governed by things like the Brown Act. Yeah, so it's just for us. I think that we really appreciate transparency. We're pro-transparency. We have posted all of the minutes of the public meeting on our website. So those are available. As we have more public meetings that are coming up in the next couple of months, we'll be posting the minutes of those too on the website. It kind of the question I have is that I've already invested significant time in my neighborhood and my community by exploring a number of different options. I don't know where this can stop. Many of the attachments that were provided were actually from the efforts in the inner Sunset and the hate. They weren't necessarily in direction with what we're doing in the Mission Dolores neighborhood. And I've got some very real concerns about where this could stop. Am I going to have to start reporting emails just amongst neighbors? Are we going to have to start recording our conversations at the dog park? Are we going to have to, spend more than the 7 hours that I've already invested in just in involving this complaint? So like the people that are here lodging the complaint, I think we also would like some idea of what the standing is, because that's going to help us focus our time and our efforts on our neighborhood and not responding to outside groups. So thank you for your time today and your consideration.
Thank you. Are there any persons or witnesses that provide any facts or evidence on behalf of the respondent? Seeing none. Yes? Please state your name and if there's a position.
Yes, my name is Jim Chappell, and I live at 19th and Guerrero, and I'm a member of the Formation Committee of the possible Dolores Green Benefit District. Such districts are the ultimate in grassroots democracy and sunshine. We are simply a group of neighbors who want to improve our neighborhood. As we studied ways to do that, we saw that with such a volunteer committee, we could ask neighbors what they wanted to improve in the neighborhood, how they thought it could best be done, and how much they would be willing to pay. I cannot imagine a more open and inclusive process. This is democracy and sunshine at its best. I'm sorry that your time and ours is being wasted yet again by the complainant. He knows full well that we are not a policy body. We are not created by ordinance. We are not created by the Board of Supervisors. We are not created by any department. We do not exercise any legal authority. We were not recruited by DPW. We formed ourselves. We do not hold a special election. If and when an election is held, it would be held by the San Francisco Board of Elections and subject to all Brown Act, sunshine laws, and regulations. Should we be fortunate enough that a GBD is formed, we will be subject to all the Brown Act and sunshine and open meeting laws and will happily comply. And why wouldn't we? It is to our every advantage to have as much participation and openness as possible. However, the complainant's sole purpose in videoing meetings and filing complaints is to intimidate neighbors and to harass the formation committee and city staff. He has no legal interest in this matter. He lives in a totally different part of town, does not have property in the subject area. He goes from neighborhood to neighborhood to harass neighbors who have volunteered to try and improve their neighborhoods. He has no other purpose in wanting to video these meetings to which any interested person can come and participate. No information will be gained that cannot be had at the meeting or by reading the detailed minutes that are online. And let me tell you, they are all online. So I ask you to please reject this complaint once and for all. Thank you.
Are there any other persons or witnesses who provide any facts or evidence on behalf of the respondent? Seeing none. Okay, members, I just want us to be just want to preface this by saying many of us are public members here. We live here in the city. This particular process occurs in various areas of the city of which we may observe or be part of or be asked about. People may have certain kind of sense or positions about it. Our job here is to really determine how it applies to Sunshine. And this is important. We've been down this road before with other different kinds of what seemingly are possibly third-party committees that were formed, but somehow they were under the rubric of either some law or statute or city government here, and in one way or another, it was either deemed an active body of some sort that is applicable to Sunshine or not. And so I think we need to keep our focus on that. Well, I recognize there may be some value to this particular type of committee and what it can contribute or not contribute to the city. We want to keep those those particular items not part of our discussion or decisions. With that, I want to also try to keep first we have to focus on and be conscious of time, because this could be a pretty long discussion. I'm hopefully not anticipating it to be long, but it could be because of the way how many laws are. This kind of trickles down from state law on how green benefit districts get created, and then determine how it gets implemented. And with some of the testimony we've heard, that there are some potential contractors that were hired by the city to help implement it and get the process going. So I want to try to keep things focused in those particular areas first, and then if there are any other issues that come up beyond that, we can, if we have time, we can do that. But I think our very first question is first to determine whether a Green Benefit Districts Formation Committee is within our jurisdiction. That's the very first thing. So we'll start with Member Josh Wolf.
I've got a question for the respondent, please.
Yes.
Was any city employee at the Mission Dolores GBD pre-GBD meeting there as a city employee? There were obviously some people may be employed for, dealing with the Tuesday bell that goes off, and that has nothing to do with the GBD. Was anyone there?
This is on the night in question, I'm assuming?
Yes.
Yes. Jonathan Goldberg was there. He is kind of the liaison with the Department of Public Works that works with green benefit districts. He's also here tonight, too, if you have specific questions for Public Works.
Sure, I don't have any questions at this point on that. Have there been other requests to record meetings by other people in the process that you've been engaging in looking into this GBD?
No, there have not.
Okay. And obviously, in your website, you speak to the need for transparency and accountability. You've described how you do have minutes of the meetings, but obviously minutes don't have every last word. Why not just allow someone to record a meeting?
Actually, after the pardon me, the subcommittee meeting, we were talking with the complainant, and I think we would be very comfortable with that had it happened prior to the meeting. And had it been set up, we had told both the presenters and the audience that was going to occur. As it was just somebody all of a sudden standing up at the back of the room and filming the audience and the presenter, so it was quite unnerving. So had that been arranged to prior to, I don't think we would have. We probably would have provided the camera.
And then, do you have any plans, whether providing the camera or recording it, to, as an organization, to record future public meetings so that is, in addition to the minutes, a record of either video or audio of every word spoken at the meeting?
Yeah, I don't think we would have a problem with that at all. I think we do want some level of idea of when this kind of where to draw the line, because again, it's my understanding that once a green benefit district is formed, it passes petition, it passes the vote, it is approved by the Board of Supervisors. It's my understanding that is when we actually would, get trained on the transparency, the Brown Act, and all the other laws associated with that. And so kind of that's where I would think that we would know the full scope of things. As it stands, I'm actually quite worried that that this is just like the filming, this request is actually just kind of trying to put us through the ringer and discourage us from pursuing this as an option. And so I'm worried about public records requests being sent to me from my email. I think Cheryl talked to me off a cliff for 45 minutes when this first came through about all of a sudden am I going to have my email, all of my email subpoenaed, and I'm going to have to spend X number of days or hours trying to sort through those and any communication that I've had related to a potential green benefit district.
Right, and we haven't gotten into whether or not you're actually governed by the Sunshine Ordinance, but in just hearing the comments, looking at the website, it seems that if transparency and accountability is a value that you've identified as wanting to stand behind, it seems like one of the easiest ways, if you're not covered by the Sunshine Ordinance, if you are covered, that's a whole different matter, is to, as an organization, record your meetings and put those on the website so that, while we have no idea how this case is going to resolve, at least that way, any question that you're trying to do something that's not above board, you can just point to the full audio files or video files.
Yeah, we had that conversation with the complainant, and I don't think had it been talked about ahead of time, we would have had a problem with it. I just think it was something that we're a group of neighbors. We didn't think of that ahead of time, and we're just unnerved with the fact that all of a sudden somebody's breaking out a video camera and kind of intimidating you with it.
All right, thank you. That's all I've got.
Yeah, of course.
Okay, so a couple of things. I think we first need to determine who or what law created this. So it stems from state law, and 15A allows for the modification or adjustments to various parks and streets and what have you. Green benefit districts are part of that. So we have to determine first, how does a green benefits district formation committee, where did that name even come from? Because it's a very common, ubiquitous name. It's part of a process. So somebody has to implement and educate the public, or the public has to find out that this exists in some kind of way. So I want to try to see if we can explore that first and try to get down to the brass tacks of how this particular body comes to exist in its current format. Yeah, Member Kanata,
I was
did
just
you have
going
a
to say
question?
that the creation of the Green Benefits District, like Commercial Benefits District, is done by a city organization. Green Benefits District by DPW. They have the information on how to create it. And definitely when you're a Green Benefits District, the Sunshine Ordinance would apply. But people trying to create one can find information online dealing with a city agency. So to me, the question is a group of neighbors, a formation committee, which is the name either they've given themselves or somebody else gave them, do they from the start have to adhere or are under the jurisdiction of open government? And the complainant stated that the department, DPW, created this. But DPW, to me, created the Green Benefit District program. To me, they don't create the people who want to start one, who get together to determine if something's going to happen.
So, but that begs the question is then under what statute does a Green Benefits Formation Committee exist? Why is it called that? Where is it named that? I mean, you're making the claim that that this just happens to be some neighbors that get together that decide that they want to have a green benefits district. But meanwhile, and I've been to one of these meetings in a different neighborhood than this one, just to observe it, and there are city staff there, and they're actually, instructing and advising the people who have started the committee. And the public of what's going on, how it's going to work, how it's implemented. The other thing, hearing testimony, is that money is being spent either for the processes of the committee from either within the DPW or elsewhere, or to hire contractors to help facilitate the process. So that is another interesting question of what's the involvement? Why is specific money being spent for this particular group at this juncture now versus later when the Green Benefit District is formed? And so I mean it's just kind of some open questions I have to determine where this is. I mean we've been down some of this road before with various things. I mean, I could take a body like the Community Police Advisory Board. Each police district has one. It's been deemed that those are passive meeting bodies. Why? Because they were created by the department head. And they make recommendations and advise the captain themselves directly. So they're deemed to be a passive meeting body. They had to create a citywide set of bylaws that applies to all of them equally. Before that, each one had their own set of bylaws, and they were operating incorrectly. So that was unbeknownst to people. There was another one where there was a code review committee of the Planning Commission. They were created by the Planning Commission, and they advised the Commission directly, but they were operating as if they were like an advisory committee, but they are, in fact, a policy body. So, it's not about what the operation is of it or what its purpose is. It's really a matter of how it got created, who it's answerable to, that we first have to determine. That's what I want to get down to, that level of scrutiny. Yep.
Vice Chair Heiler. I had two questions. One for Mr. Goldberg, if you are here, if you could approach. And then as he's approaching for our Deputy City Attorney, Wolf, you identify, I think correctly, that we first have to get to jurisdiction. Are they a passive body, non-passive, or neither of the above? And I see your notes here, but I would just welcome your take on what you think they are. Just get right to the point. Like, I mean, you lay out things for us to consider. I get that. And you also mentioned some things of funding, and I think Mr. Goldberg can probably help us answer that. But just on what you see so far, what's your position of this formation committee? Bear with me, Mr. Goldberg.
Sure. So I appreciate the question. I think that my role here as the advisor is to lay out what I see as the relevant factors, the relevant law, and point out what I think are the good questions to ask, where maybe the forks in the road are, maybe where the nuances are and the facts for this body to explore. And that my role isn't necessarily to tell you, do I think thumbs up or thumbs down one way or the other. So it's not as if I don't appreciate, your directness of the question, or but because I do.
I should have veiled the question more and made you say something.
But I don't feel that's my role here.
Okay. We may not go with your decision, but I was just curious to see.
Fair enough.
On your take. I know there's certain questions have to get to, but okay. I'll move to Mr. Goldberg, and you came to the complaint committee and you answered some questions. And if you want to just maybe restate that, I think that'll shed a lot of light for the full task force here as to how you got in touch with these folks and kind of the steps that have gone and where you think they are in this process.
Sure. Thank you for your time this evening. My name is Jonathan Goldberg. I manage the Green Benefit District program at San Francisco Public Works. I was approached by neighbors in the broader Mission Dolores area who had secured add-back funding to look at ways that they could sort of address the cleanliness, quality of life issues that, as Conan had referenced, stemmed from a recent shooting in Dolores Park, sort of cleanliness, trash around the periphery of the park and in the park itself, and sort of issues along the 18th Street corridor. Neighbors went through sort of a deliberative, process with the supervisor's office, with the mayor's office, who had the funding at the time, and that was secured through a sort of a mayoral add back to explore various opportunities and programs that might be able to support a little bit more ongoing, sustained improvement to their community. A portion of the funding was used for regular sort of steam cleaning and pressure washing along 18th Street. And sort of at the end of that sort of 9-month cleaning period, neighbors said, we want to sort of redirect the remaining funding to look at something that we can sort of better manage ourselves and explore something a little bit further in the long term. The mayor's office suggested that they get in touch with me. I met with them and I said, this is the general process. These are the steps involved. And so that sort of initiated the informal conversations for neighbors to explore what forming a green benefit district may look like. The city takes a very, very conservative approach when forming these sorts of districts. They really want to make sure that there's extensive community, neighborhood, stakeholder engagement throughout, and really to ensure, what it is that neighbors are desiring, if there's any desire or interest in supplemental services and improvements that the city is not currently providing. What is the sort of mission, the focus, and sort of Public Works really does act as that sort of hands-off sort of advisor. Once they sort of go through a public survey to determine whether or not there is sort of interest and support for moving the process forward, these are requirements that the city is sort of placed on the process and not ones that are sort of legally required as per the formation of any benefit district. Neighbors sort of work with stakeholders to determine, is there a sort of a defined area that we want to move forward? They work to draft a management plan. They hire a consultant to draft an engineer's report. There's a laundry list of items that are required per state code and also per city ordinance, Article 15A. And, those documents are reviewed and approved by Public Works and the city attorney's office. Those documents are reviewed and approved because they become legislated by the Board of Supervisors when the neighbors successfully reach that petition threshold to introduce legislation at the board. Sorry.
Okay, so where is this body in your...
So they're still drafting their documents. and they're still engaging conversations with neighbors on, what exactly, what specific sorts of services would people like to see. I'm not aware of a sort of definitive timeline that they're sort of trying to reach. There's no imposed timeline for them to reach.
Go ahead, Member Kanata.
I have a question. So, as Department of Public Works yourself are giving advice to these types of groups regarding their meetings, do you advise them that they should have meetings under the Brown Act and Sunshine Ordinance guidelines, or is that not part of the advice?
So, generally speaking, I am not privy to a lot of the details that folks are sort of discussing, meeting about. I don't believe it is really sort of my role to be keeping tabs on every single conversation that these members of the public have to date, because it is a process that is driven and informed by neighborhood property owners.
Thank you.
And Mr. Goldberg, thank you for agreeing to appear and speak here. I know you're not party to it, but I think it's important for us to hear from the horse's mouth on how the whole process and who's involved. When was this Green Benefits District process created?
By the Board of Supervisors? Or
is this
when was Article 15A?
Is this an old process, or is this new? Or
the city originally adapted the state's Streets and Highways Code in, I believe it was 2004, for sort of Union Square. Since then, neighbors in Dogpatch and Potrero Hill wanted to look at adopting that community benefit district model to fit more a residential neighborhood. The city attorney at the time felt like there needed to be some changes to the sort of code to better differentiate the sort of benefits that would be accruing to residential property owners. And so, in turn, then Supervisor Malia Cohen, working with Potrero Hill and Dogpatch neighbors, introduced Article 15A. Currently, the city attorney has advised that largely the sort of abilities and provisions that what a green benefit district can do and what a community benefit district can do are largely sort of one and the same. It really comes down to sort of the departmental sort of focus for sort of the program. One is in the mayor's office of workforce and economic development, and given that there's only one green benefit district, they have been very successful in sort of partnering with existing neighborhood organizations to sort of promote and support community-driven initiatives.
Okay. And how long have you been working with this program?
So I have 4 years would be April 25th.
Okay, so you weren't there for were you part of the process to create the Green Benefits District process?
I was not integral to the sort of process to create the Green Benefit District process. I was part of a private firm that was advising neighbors. We were at the time the sort of sub-consultant working directly with the assessment engineer on the assessment methodology and the service plan for
city employee.
No,
assessment engineer.
No.
Oh, okay.
It was private. We were consulting with sort of the consultant that was leading sort of the public organizing, private consultant leading the private organizing effort with Dogpatch and Potrero Hill neighbors. Okay, and I've just got a couple of more questions, and I'll let others chime in. So you're pretty familiar with this process, okay? And now you work for the city, okay? So tell me, whose idea it was to create
a Green Benefits District Formation Committee, and why?
So it was neighbors. Neighbors decided to sort of initiate the process to continue their.
Who created that name?
So I think the parlance has been carried over from community benefit district steering committees, and at least in the dog patch in Northwest Potrero Hill example, neighbors felt like they wanted to be. It's like, well, what is a steering committee? Our interest is to form a green benefit district, so let's call ourselves a formation committee.
And so you're treating the Green Benefits Formation Committee as the same as a Community Benefits Steering Committee?
Correct.
Okay, so let's say for all intents and purposes they're one and the same.
Correct.
Okay, so who does that body answer to?
So ultimately they are sort of answer to themselves. They have to vote themselves into existence. The city advises them.
Let's take it one step at a time. How does that happen?
So legally they have to create a management plan, which is a legislative document.
So legally under what statute?
Streets and Highways Code 366 at SECWR.
Okay.
They have to have a sort of a definitive parcel map, an engineer's report, an explanation of sort of general and special benefits, the amount assessed to each individual parcel. That is a complex document that it does not get created sort of overnight. And so, the city has created programs in the mayor's office and has offered the sort of expertise through Public Works for neighbors to explore, how they can initiate this process and form a green benefit district or a community benefit district.
So nobody in the city assigns or approves anybody to be for this formation committee to be created, and
No.
who sits on it? Okay, thank you. All right, I'll stop there for the moment.
I'm just going to follow up on
Vice
that
Chair.
question. At what point does it become an official advisory committee under the mayor's, jurisprudence?
So there's several legislative hurdles that are involved. So there's a period of time sort of after the official ballot tabulation, and the Board of Supervisors and the Department of Elections announce those ballot results. If those ballot results are indeed in favor of formation of the district, the steering committee becomes a de facto interim board of directors. That body is responsible for either setting up sort of a new 501c3, procuring bylaws, entering into a legal agreement with the city that has to be reviewed, signed by the city attorney, and voted on by the Board of Supervisors so that they can sort of receive their assessment funds that are collected by the city and dispersed to the organization to fund those special benefit services. The alternative is to sort of work with an existing established community benefit district organization. For example, Discover Polk recently, which is sort of the middle Polk neighbors CBD, recently decided to contract with Lower Polk CBD to basically ensure to lower their administrative costs.
Okay, and just one follow-up question. You've mentioned funds in there. And have any city funds been directed to this formation committee directly? The answer is probably no.
To pay the formation committee?
Or for their use, exclusive use?
So for their personal use, definitely not.
Okay, no, but I mean, but yet they have some influence on like the street cleaning on 18th Street, the steam cleaning, etc.
And this was done in sort of the consultation with the supervisor's office, who sort of secured or allocated the funding to the mayor's office or to a specific city department for those in additional
but it's just they're voicing their concerns and you guys act on it, but it's not going through that body in any way, shape, or form. Okay, all right, that's all I have.
Okay, Member LaHood and then Member Josh Wolf.
Yeah, through the chair, I have a couple of questions. So in this particular case, a group of neighbors came and sought help from the city, and the city provided some assistance. I'd like to know two other scenarios. What if a group of neighbors was operating independently and trying to form a green benefits district, didn't seek help from the city until they got almost to the finish line? And then what if a different group of neighbors overlapping in the same area wanted to create a community benefits district, but not the same people, maybe slightly different? Would you force them to work together, or would you consider both proposals when they came forward? I'm trying to figure out if the issue here is receiving help and money from the city, or just the fact that this is happening with the intention of eventually becoming, a policy body or a passive body.
Maybe a better question: can there be more than one formation committee?
That's a great idea.
I've never faced that question. I believe there could be. However, when the time comes, benefit district boundaries cannot overlap. So the process requires a measured level of support during the petition phase, and then sort of support during the ballot vote. And if you're not going to mix your porridge that's too hot and your porridge that's too cold, you're never going to find your Goldilocks.
But I think what she's asking, I think what she's asking is, if, let's say, for the same area, the same boundaries, so here we're talking about Dolores Park for all intents and purposes. What if there were 3 formation committees of different neighbors that have different idea about what they wanted it to be? What would does DPW get involved at that point, or do you just receive all the work that they're required to through the process? And then the question becomes is, who creates that requirement? How does it get determined? What happens then? These are more of my other questions, but just what happens after you receive all those you just one or all? Who does it then go to? Is it actual official advice, or recommendation, or a proposal for a policy body to consider, or a department head?
So in the example of Dogpatch in Northwest Potrero Hill, so neighbors in Dogpatch realized that their neighborhood was going to face a sort of a wave of density and development. There's virtually no development whatsoever in Potrero Hill. So when they went through their, and these are 2 disparate sort of zones that, under the management of one sort of overarching board of directors, the sort of services and the service allocation and improvement allocation of assessment funding for Northwest Potrero Hill was done in consultation with those neighbors, and in order to meet sort of their goals, which were more maintenance-based. And for Dogpatch, they had a different allocation for services and improvements of their assessment funds that was more focused towards capital improvements. So both sides, saw the mutual synergy of working together, and sort of they went hand in hand to form an entity that could be sort of fit under one roof.
And if they hadn't been able to come to that agreement and were competing with each other, there would have had to been a dividing line that says this group is over here and this group is here, and there's not an overlap. So if they weren't working together, you couldn't have an overlay.
Correct.
So it's more of an overlay versus an overlap.
Yeah, so there's
if we're talking about the same swath of land.
No overlap can exist between 2 districts.
According to...
Does that mean they...
Oh, I see. So you're considering that a formation committee is actually the purpose of the existence of a formation committee is to create a district. So whatever they create is proposal for this kind of district, and then another one is for this kind of district, even for the same geography. And so they can't you can't have two that clash.
Correct.
Okay, got it. Okay, Member Josh Wolf.
So it sounds like you said that the Community Benefit District and the Green Benefit District are legally essentially the same entity, correct?
There's, I would say, 90 to 95% legal overlap.
And I believe you said that the first Community Benefit District was Union Square in San Francisco.
Under the city's modified legislation, the first, it was still Union Square, but it formed under the state statute in 1999, I believe.
Right. And assuming you may or may not have been in the city, but obviously you weren't working for the city in this faculty in 1999. But do you happen to know how those meetings around the group that formed that Union Square CBD under the codes that you just described, how those meetings worked?
I'm not privy to those details. If you don't mind, there's one gentleman in the room who may be privy to those details. He's been a longtime Union Square Business Improvement District board member.
Through the chair, is it all right if we...
Would you like to hear from this person?
Yes, let's go ahead.
Okay, sure. If he's willing to, he's already party, so sure.
Sure. My name is Jim Chappell, and in 1994, I became executive director of an organization called SPUR, a nonprofit civic organization. And one of the first things and the office was in the Union Square neighborhood, and one of the first things I did was work with our members and other neighbors and looked for ways to improve the neighborhood. And we actually had a national conference in San Francisco and brought people from around the country who talked about different ways of improving neighborhoods. And it became quite clear that a business improvement district, at that time, I think there were over 1,500 in the country, was something we should pursue. And so for several years, the neighbors worked together to form that district, and ultimately there was an election and it was passed.
But the meetings, the formation committee, if we were calling that, I guess back then we were calling it steering committee because this is the first time we're calling it formation committee. But the steering committee meetings for the Union Square Business Improvement District / Community Benefit District, were those meetings public? Were they organized through, where did they take place?
They took place in a hotel meeting room. Yes, they were public.
If I can interject, I think the next question would be, was it required that they be public?
No, we were a private group of people meeting, but of course we want it public. You want as much participation as possible.
I understand that, but our jurisdiction is to see what applies to the law. So it's, while good sense and goodwill is one thing, we're here to find a legal standing of whether it is or is not. Yeah. So continue.
Yeah, I think actually, while it's helpful to get your historical perspective, you were a nonprofit entity at that time, not the city. So in terms of the legal requirements for public meetings and stuff, that was outside of your scope. So I appreciate your input, but if we can bring back the gentleman from Mr. Goldberg, thank you so much.
And perhaps one clarification I would like to make. I did not schedule the meeting date. I did not set the meeting time. I did not, introduce or lead the presentation. I did not pay the rental fee that was associated with using the space. That was all determined and planned out by the formation committee.
But at the same time, it sounds like there is, even beyond your staff time of yourself, city funds that have been used towards the direction of creating this entity, or at least towards the direction of exploring whether or not this GBD would be created. Is that correct?
That is correct.
And so I'm curious, I see how in this case we have this private group of people working with you to schedule a meeting that they're calling a public meeting, but isn't a public meeting the way that we as a task force engage with public meetings. And it seems like the simplest approach here is, rather than them scheduling this meeting, we're already spending city dollars, you're already spending city time. If your department, or if you as part of the city's public works department scheduled the public meeting, then in conjunction with these people that are organizing the GBD, then this becomes much less unclear. It is the Department of Public Works is scheduling a public meeting alongside people that are interested in forming a GBD, and it's cut and dry a public meeting. At this point, what we have, as I see it, and please fill me in if I'm missing something, is that in essence we have a private group working with the city to create a quasi-public meeting, but because they're the ones driving the train, whether or not it's under the Sunshine Ordinance is this thing that we have a very difficult time parsing. So why isn't it better to just have DPW drive the train in these situations?
Because DPW does not determine the services. It does not determine sort of the nuts and bolts components of what is ultimately in a management plan and engineer's report. There are some sort of legal guidelines, legal criteria for what is required. You have to reference, what your governance structure is going to be. You have to reference what your sort of annual budget and your annual assessment collection, and that is determined by community members.
I'm not suggesting that DPW drive the train in terms of making these decisions that the community members absolutely need to make. And obviously the committee that's making these decisions needs to be in charge of their committee. But it seems like DPW is creating a container for this to happen, and yet not going all the way of actually instantiating the container and saying, this is the container that this group is having, because you are participating in the meetings. Just a side question. When this individual wanted to film and was denied, did you in any way weigh in on the debate?
I don't believe I did. The request to stop filming was made by Conan.
Right. Again, why does it not make sense for DPW to be the agency setting the public meeting so that there isn't this weird ambiguity and gray area?
Because this is fundamentally sort of a locally driven, effort. I was not required to attend any 3 of those meetings. I did want to make sure that there was an opportunity, in the event that there was a sort of specific, detailed question about GBDs or the GBD formation process, that there was someone on hand to be able to answer those. I was not required to attend those meetings per se.
Great, thank you.
Thank you. Member Kanata.
I just want to get clarification on the funds. What city department did the funds come from, and were the funds directly given to the formation committee, or what I heard before, they were given through an effort to keep the streets cleaner, and given to whomever by whomever?
So the funding resided with the mayor's office. I do not recall the specific language in the city's sort of budget line item, but the sort of supervisor and the folks that were sort of working closely with the supervisor's office to sort of request city assistance in this effort, after a period of time of sort of steam cleaning, they requested that if we could look at a longer term sort of organizational process that could help sustain those cleaning investments.
Okay, so there was money given to keep the sidewalks clean, a little maybe whatever, beautification, cleanliness. All of that money wasn't spent on that?
That's correct.
And then so the remainder of that money, how did it went to the formation committee, and how was it used?
So it went via a grant that was through the mayor's office to support the sort of organizing of the formation committee for exploring a green benefit district.
Okay, thank you.
Yeah, Vice Chair.
I think we're getting. I mean, this is very interesting stuff because it's right on. You know, is it a? I think I'm pretty happy. This is not a policy body. I don't think it's a passive meeting body yet, and that's kind of what we determined at the complaint committee, and that was the basis of our recommendation. Mr. Goldberg has explained there is an election process that makes it a formal advisory committee. To my satisfaction, so I'm going to propose a motion that we do not have jurisdiction in this case.
I would second that motion.
Yeah, you'll have a chance to talk after.
Okay, so first of all, we should not make any motions until we finish with the hearing process, which includes rebuttals. That's when we make our motions.
Okay, but I'm slightly confused because aren't we even, before we even get to the merits of the case, we're trying to determine jurisdiction. And we've been talking a lot about merits.
You've already determined you've already determined jurisdiction that's why it's here.
No, we recommended.
We recommended that there wasn't jurisdiction, and because of all of these issues and how just the whole process, we wanted the full board to determine jurisdiction.
I see. Okay, so the question before us is whether it's jurisdiction. Yeah. Okay, so first we have to. Okay. All right. So there is a motion on the floor to not to find jurisdiction. Okay. So I'm a little. Yeah. All right. I wish that was made a little more clear to me because we started a regular hearing process.
Well, I thought.
Well, we started talking about jurisdiction, and then we went to the merits, and I've been trying to pull it back to jurisdiction, which is why I asked the DCA because we got to get past that hurdle first, I think. And it's actually been informative to hear the rest of it, but I think it reinforces in my mind that we don't have it. Okay. That's the motion.
All right. Was that clear to everybody else? Okay. I'm sorry. My bad. All right. Okay. Well, there's a motion on the floor.
Public comment?
Well, first of all, are there any? We can make comments first. Yep.
I'm still confused as to whether or not we should permit rebuttals from them before. I'm just really confused about the process here on that because we've heard their introductory remarks.
Well, consider it then as if you were to be in a complaint committee, if you were running a complaint, this is probably as far as you would go before you would make a decision anyway on jurisdiction. You wouldn't run rebuttals.
Okay.
So let's run with that at this point. Okay. No rebuttals because we're determining jurisdiction. No jurisdiction was found at the committee level. It was pushed up to this body to find jurisdiction first.
If the motion fails, then we keep going, right?
Right. If the motion fails, then we have to. Have a motion to find jurisdiction. I mean, it's just,
correct.
You could do it the other way around. We can say, do we find jurisdiction, and then take a vote. I mean, that's really the way it should go.
I think we needed some discussion there to get to.
No, I understand that. That's fine. Clarification, because that's what you would do in a complaint committee, right?
And just for clarification, in a subcommittee level, if a subcommittee finds no jurisdiction, it does not have to come up here?
That's right. Generally, because the task force has given authority to those complaint committees to determine jurisdiction or not, but it's got to be reported here.
Oh, absolutely.
And if the task force decides otherwise, then it could.
But how? Okay, so how would the task force decide otherwise unless we went through a process like this?
Because somebody would bring it up.
Or read it.
Yeah. Okay. You read through the minutes of those committees, and somebody could say, I don't agree with that committee's decision. I want the task force to make a decision, to reconsider it in that kind of way. Okay. Yeah. Member Joshua.
I think that even if the committee doesn't find jurisdiction, it still has to go to the full task force because the complainant has a right to a hearing in front of the full task force. So if the committee doesn't find jurisdiction, we still have to have a hearing in front of the full task force in order to follow through with our.
That's why we sent.
And that's what we've done. So, but did the committee find no jurisdiction?
Exactly.
You took a vote.
Yeah.
No,
We voted to send it up here with
with the recommendation that we don't
that it was
see
no
jurisdiction. No, I don't know if that's the
With the
same thing.
recommendations. Okay.
Okay. I mean, that's all we can do at the subcommittee level.
That's
Okay,
what
that's
I'm.
fine.
That's what I'm trying to say. Is I don't think that they can actually make that determination.
But
They
I
have
think
to just recommend
Chair
it.
Wolf is saying that the subcommittee has been given authority to, first and foremost, determine jurisdiction, because that's partly what we're doing, and then sort out the apples and oranges. So yes, we could have just right off the bat said, sorry, we don't see jurisdiction
No,
here.
I think that technically the subcommittee has the authority to find jurisdiction, but they don't have the authority to not find jurisdiction or to
Well,
find
if they
no
don't-
jurisdiction.
If they don't find jurisdiction, they can't move forward, can they?
No, because it has to move forward because
I
every
see. So-
complainant has a right to their
full
complaint be heard
process.
before the full
So we
task
say we
force.
don't find jurisdiction, and we recommend, and we
Just
forward
what
it to
we
the
did,
main.
and that's exactly what
So
happened.
here, so here we are. So I'm going to rephrase the motion. Okay, the motion is to find jurisdiction. Those who say no means that there would be no jurisdiction. Those who say yes means that there would be jurisdiction,
Fine.
because that is always the question that is before us.
Okay, so let's start with
Okay?
that. I'll accept that change.
Okay.
Wait, if you make the motion to find jurisdiction, you have to vote yes on it, though. So we have.
I don't have to.
Are you sure?
Sure.
Okay.
No, if you're the question before you would be to find jurisdiction. If you do not believe that the Sunshine Ordinance Task Force has jurisdiction, you would vote no.
But you can make a motion and then vote against your own motion.
So tell you what, I'm going to withdraw the motion. I'm not making that motion.
Great.
There we go.
I was just asking to rephrase the motion in the way that we generally make these motions.
Okay.
So that it avoids confusion.
Let me just make it cleaner and just withdraw the motion.
Mm-hmm.
Second agrees.
Do you agree to withdraw the motion?
Sure.
Okay, go ahead. Motion is withdrawn.
Okay.
Now, would someone like to?
So I'll entertain a motion to find jurisdiction on this matter.
Do you have a second?
I'm entertaining a motion.
Looking for a motion.
You're looking for someone to make the motion.
Yes.
So again, the question is, if you make a motion to find jurisdiction, do you have to vote yes on that motion?
No, you can vote no.
Okay, I'll make a motion to find jurisdiction.
Is there a second?
Now this is.
I'll second it.
What if no one had seconded it?
Then the motion would die.
Okay.
And the matter would be essentially closed.
Okay.
At that point. But that is not. It's not the point here, though. Is our duty to find whether it has jurisdiction or not.
Exactly.
So the question has to become before us.
We have to ask.
In the best interests of everybody. Okay. So
I'm comfortable with it.
Let's not mess with our system here. Okay. All right.
Public comment.
The motion is to find jurisdiction.
Find jurisdiction.
It was moved by Member Kanata. It was seconded by Chair Wolf. Okay. Is there public comment to find jurisdiction? Yes. If you're not party, you have to not be party.
You have to not have spoken.
Yeah. You have not been spoken before.
Good evening. Thank you very much for spending your time on this. It would be a dangerous precedent for you to not find yourselves having jurisdiction over what is a formation committee. I think it's all well and good for neighbors to get together and want to improve their neighborhoods. But the moment the neighbor in Mission District or the neighbor in Dog Patch uses funds that are in the city's coffers to organize themselves, to set up a website, to pay a consultant $150 an hour to attend community meetings and rally support for their ideas, this formation committee, I submit to you, is very, very public. It needs to be public. It cannot be in somebody's living room and like, oh yeah, let's do this. No, if you're going to spend my tax dollars, I want to know what you're planning to do with it. Am I entitled to attend their coffee shop meetings? Of course I am entitled to do so. And as an active resident in my community, I will do so. But it would be a travesty if you decided that you have no jurisdiction at this level. Ironically, once a GBD is formed, it is a non-profit. It's a private entity. In order to shut down and change anything in the GBD, the rules are onerous. 50% plus one, not my vote is one vote, your vote is one vote. If my property is 3 times the size of yours, my vote is 3 times the size of yours. How did they get the dot patch petition through? They set a deadline. By the time the deadline rolled around, there wasn't enough weighted votes. Phone calls were made. Hey, you didn't send your votes in. Extended deadlines, and yet extended deadlines. And how do I know this? Well, because one of my very diligent neighbors submitted a request for this information to this very board, and that's how we know. I think it would be a travesty for you to say, oh, no, we have no jurisdiction here. Thank you for your time.
Is there any other public comment? People who have not spoken as a witness or a party?
Chair Wolf, I know this is out of the ordinary. We're about to take a vote on this, but could I call Mr. Goldberg back to have him explain the grant process a little more clearly? Or is that
I don't think so at this point.
Okay.
I mean, that's more getting into the meat of the issue. We've had a lot of testimony. We've had almost an hour of testimony here on this.
Okay.
I'm going to try to lobby you folks on finding jurisdiction for this. And the reason why is because read the Sunshine Ordinance with regards to both what a passive meeting body is and what a policy body is. And I think it's important that we get to that crux of this matter, because for me, in the end, from all the testimony that we've heard, this body is going to create something that advises or makes a recommendation for policy to be passed. Okay? So under a passive meeting body, any group that meets to discuss with or advise the mayor or any department head on fiscal, economic, or policy issues. Okay? Under a policy body, any board, commission, committee, or other body created by an ordinance or resolution of the Board of Supervisors, or any advisory board, commission, committee, or body created by the initiative of a policy body. I still haven't heard, I'm not convinced. I haven't really heard enough about how this process got created, who created the process, how is it funded, was it created by ordinance, so on and so forth. So I'm interested to hear more about this, because I'm not confident that we don't have jurisdiction. I believe that we do. Okay, Member LaHood and Member Josh Wolf.
So what I brought up before about if you have a group of neighbors who are working independently, doing this on their own, maybe spending their own money, because they're still working toward the same goal, does it matter that they haven't received city money or aren't coordinating with the city until they bring it to the end?
It has nothing to do with money. It has to do with whether they meet to discuss with or advise. As a passive meeting body, to meet or discuss with or advise the mayor or any department head on fiscal, economic, or policy issues.
So the point is, when they start interacting with the city, that's when it's triggered. So if you just have neighbors talking with each other and they haven't talked to the city, but they're like, I researched this on the website, we can do this.
So if a neighborhood council were to get together, it's unincorporated, and wanted to talk about a community benefits district, they can talk about it fine. Okay? I think that's not what we're concerned about here. What we're concerned about here, this is specifically named the Green Benefits Formation Committee. Who gave it that name?
I want to know where you draw the line. When does it become? When do they cross the line?
That's right, and that's why I'm asking for your vote to support this motion to find in jurisdiction, so we can find out, and then we can determine whether this actually has the merit for jurisdiction or not. Truly, I mean, this is like creating a water district in the largesse of the state. It exists somewhere kind of ubiquitously between different cities, okay? I mean, it's these community benefit districts and green benefit districts act almost somewhat of like a subset in that same kind of way. And they have their own powers and authority. And there are various community benefits districts in the city. So anyway, I urge you to support finding jurisdiction so we can truly find out more. I think it'd be a travesty to claim that we don't have it. I don't believe that we've heard enough or gotten enough information. Member Joshua.
I no longer have laptop power. Does anyone know, is the respondent include DPW, or is it just this formation committee that is the respondent?
According to the complaint and all the documentation, I see it's complaint number 18086, Mark Sullivan versus Mission Dolores Green Benefit District Formation Committee.
So I think that we do have jurisdiction over this issue. I do not think we have jurisdiction over the named entity. At this point in time, they don't exist as anything other than an extension between private parties and DPW, and they sort of meet in this matrix land in the middle. So if the complainant had named DPW as a respondent, I think we have jurisdiction over DPW's involvement in facilitating this meeting group, but I don't think this meeting group exists in any manifest way for us to have jurisdiction. Nothing exists. It's still transitory. So I think we do have jurisdiction, but I think it's over DPW, not over this entity that is currently named.
Member Canada.
So my feeling is that that dividing line is when a vote is taken and a green district is set up. Before that, I was, again, a personal experience. I was on the board of a neighborhood group for 11 years. We got money from the mayor's office to steam clean. We used that to beautify the neighborhood, and we also used that to work with DPW to get a DPW ambassador in the neighborhood full time. We had open public meetings, but we never had any video. We were not subject, to the Brown Act. I view this as the same type of thing. Once they become an entity, then and if they become a 501c3, then they're under the regulations of 501c3s. So that's just my opinion.
I'll call on myself. I just want to remind folks, and based upon Member Kanada's explanation, is that if a organized body receives city funds, they're obligated under the Sunshine Ordinance under 12L. And there are specific rules for nonprofits that receive city funds. So it's not like you can a nonprofit can act in a vacuum when they receive city funds.
Right. But
they have to have like mandatory open meetings.
But at this point, they're not even a nonprofit. They are.
I understand that. My concern here is that the Mission Dolores Green, we have not been able, I have not heard enough evidence here in testimony or in documentation. I see no documentation from the Department of Public Works that runs this process, okay? Because if people wanted to, why do people form a formation committee in the first place? They form it in order to try to implement a tax assessment for use of funds in that particular in creating that district. There's a process that has to be followed either by law or by policy or by guidelines that is created by city government. And then the question that I have is whether that body is it's required under that a process, and what is the purpose of that body? Is it the purpose to advise other people? Is it a purpose to create proposal for policy? Is it to create recommendation? I don't still know. I mean, I look at the website for the Green Benefits District, and they've got it phase 1, phase 2, phase 3. Convene meeting of interested property owners. convene. That means the department convenes it. That's what it sounds like to me here. It sounds, I mean, I'm just reading this is the only documentation that's been provided to us with regards to this meeting. And so I feel I can't even make a decision of whether this is in jurisdiction or not.
Can we ask for some testimony on that? On who's, because I don't, when I hear that, I don't think that the department is convening the meeting.
I don't either. And through the chair,
yeah.
If it's already 6:50, we have. You said you didn't want to spend too much time on this. I think we should either have a vote or we should continue the entire process.
You want to call the question? Or you want to call the question?
What does that mean?
That means you want all debate to stop and to move immediately to a vote.
Yes.
Okay.
I'll second that.
Call the vote. Roll call, please.
So to be clear, a yes vote means you think
think
we have jurisdiction, and no vote means you don't think we have jurisdiction. Thank you.
A second. Member Kanata.
No.
Member Kanata, no. Member Chair Wolf.
Aye. Yes.
Doesn't the second make the?
I made the second.
Yeah, he was the second.
Oh, sorry.
You vote aye?
Aye.
Aye. Member Yankee.
No.
Member Yankee, no. Member Martin.
Aye.
Member Martin, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Tesfaye.
No.
Member Tesfaye, no. Member LaHood.
Aye.
Member LaHood, aye. Member Hinsey.
No.
Member Hinsey, no. Member Highland.
Pass.
Yeah.
Want to vote?
No, he's passing. Move on to the
Passing,
next person.
okay.
Isn't he the next person?
Yeah, there is no next person.
Oh, you're the last person.
Am I?
Yeah, you're the last person.
I'll say yes.
Yes. Equally divided.
Can't
be.
We're
It's
nine.
five yeses, 4 noes.
4 noes.
Must have
yes.
forgotten someone who didn't vote.
Who didn't vote?
Everybody
Remember,
voted.
Kate's not here.
Member Hinsey?
Everybody voted.
I voted
no.
It's 5-4 yes.
Yeah.
Through the chair, can we not hear the case now? And
Yes,
continue the case?
I will
Thank
propose.
you.
So the motion passes to find jurisdiction. I will now entertain a motion to continue this item.
I'll make that motion.
Second.
So moved by Member Kanata, second by Member Hinsey. Any discussion on continuing? I think not. Any public comment on, this could be anybody at this point, any public comment on continuing?
Yeah, I'm a little. I'm a little mystified that a 5-4 vote would be passage, since, as I understand, is this a procedural vote or a substantive vote?
This is to find jurisdiction.
Okay, is that a procedural vote or a substantive vote?
It's true. You need 6.
Because if this is a substantive vote, it requires 6 votes to pass.
Where that's in our bylaws?
Yeah.
Yes.
Absolutely.
Mm-hmm. Okay.
The question is whether jurisdiction is a substantive decision or not.
Right. And I'm not sure. I'll have to defer to legal counsel as to whether the finding of jurisdiction is a substantive or procedural vote. I don't know that. Is there?
I don't know off the top of my head the answer to that here. In other legal contexts where jurisdiction is
It
an
is.
issue, it certainly is.
Is what?
A substantive issue and not procedural, whether like the court has jurisdiction to hear a matter or to bring a party before it.
Procedural would be like scheduling or something like that.
Mm-hmm. Okay. All right. And the motion fails. I'm a little concerned that if people didn't know that ahead of time, if that would have changed the vote. But
I want.
Well,
Member Josh Wolf.
I'm a little concerned that if we had a motion to not find jurisdiction that passed, that then would establish that we don't have jurisdiction, but instead we have a motion for jurisdiction that the majority of the people that voted for, that then concludes authoritatively that we don't have jurisdiction. That all seems weird.
But it would be the same either way.
Well, no.
It would require six votes to fail and six votes to approve.
So you would have no decision either way.
Okay, that's fine. But either way, I feel like we have a non-decision. Like we haven't established we don't have jurisdiction. We just have failed to establish we do.
But the initial motion was to find no jurisdiction, and that was changed because we have to find, because the question always is, do you have jurisdiction or not? I mean, we could take.
I mean, it's somebody you want. I mean, you can reconsider the item, reconsider the vote, and it brings it back to the point of debate, and then we can just revote.
But if we revote on the same motion and that we get the same result, Member Wolf's going to have the same question.
No,
it's Groundhog Day.
But the point is that the first having knowledge that this is a substantive vote. I don't know. Would that change anybody's vote?
Did anybody think this was not a substantive vote? I mean, every time we voted, it's been a substantive vote.
Okay. Motion fails. Let's move on. The motion to find jurisdiction fails, which means that the task force believes that it does not have jurisdiction. It does.
Should we still take the public comment from anyone that wants to weigh in on this? Because it seems like we basically had a public comment session. Rick Nee successfully pointed out that we got things screwed up, but I'm not sure we shouldn't still allow.
I asked for public comment. Mr. Nee came up to the podium.
No, I know, but there's someone with his hand raised.
I understand that, but we've already voted.
He's a party.
We've already asked for public comment at that point.
No, he's not a party.
But we don't take point of order from the gallery. That's the point of order comes from members here. No, we didn't. I asked for public comment.
Public comment.
The process is we have a motion. It gets moved and seconded. We have our debate, and we ask for public comment. We can have more debate, okay, and then the public comment is closed. Once we take a vote, the item is done. We don't.
But Chair Wolf, there was a motion that was made that didn't make any sense because we basically undid the other one, which was we were in the middle of public comment from Rick Nee when we realized that our addition was bad. So we had a public comment section that we opened by the motion that was null and void.
You called for public comment after the vote was taken. And I came up and gave you some comments. This gentleman has as much right as I do to speak.
That's essentially.
Public comment was asked for public.
The public comment was for a motion, a follow-up motion for a continuance.
Oh, for continuance. So we're okay. So my bad. So we're in the middle of continuance.
But we don't have jurisdiction.
I understand
we can still hear the public comment. Yes.
Oh, you're confusing me on where we are in the process. We're now in public comment for the continuance. You brought up an issue of whether this is valid or not. Okay, we'll take that. We can take that up in a moment. Let's finish with the public comment on this motion first, and then I'll address your point of order.
No. All I was asking was to hear the rest of the public comment.
No, you made a specific comment about whether this was valid or not because of the way the vote went.
But that's not what I'm addressing. I'm addressing let's continue the public comment. That's all I was asking for.
Fine. Member testify.
So if the original motion had failed, we wouldn't have a new motion for continuance. That's what the issue is. Mr. Nee made comments on the continuance motion that we shouldn't be having a continuance motion because the earlier vote failed.
Right.
That's Just my comment.
So the request is to allow a member of the public to speak even though the motion is dead.
And yes.
Okay, fine. Everybody wants that? Okay, great.
Sure.
Sir, please come to the microphone. That's right. Take your time.
My point is, wouldn't this be procedural rather than substantive? Because the effort, what you were looking for was to be able to gain more information. I would say that would make this procedural. Thank you.
Thank you.
Sure.
Well, he's a member. He's a participant.
But no, it's on the because this is
on the continuance.
This is on the continuance,
Okay.
which is not part and parcel.
Yeah, I just wanted to point out a few things that in your documentations, the supporting documentations, there are documents that show Jonathan Goldberg as the organizers of meetings before any public meeting with the formation committees. I don't know whether you have it by PDF, but it's PDF 114 through 120. Those are the page numbers.
I'm sorry. This is public comment pertinent to the continuance?
Okay, but it's
we can't unless we approve jurisdiction to be able to move the case forward. We can't hear any more substantive.
All right. But you've heard jurisdiction. All the comments that you basically heard at the end for jurisdiction was from one side.
I understand that, but we're dealing with the technicality of our own making. So, yes.
Steelstra, in the process and listening to you think through the process and ask the questions, and the chairman yourself said, I think we need more information. And there was not enough time to fully give you all the information you want. Mr. Kanata, I appreciate the volunteer efforts that you work with city departments to get funds to improve projects in your neighborhood. This is an effort to get city funds to fund an entity that will then tax individuals in a district. So it is of vital importance that members of the community know about it, that meetings be public and open, and that any communication with Department of Public Works or the Economic Office that is also now involved, any city involvement where tax dollars are involved, we need to hear about this. You asked for experiences in the Union Square Formation Committee. Well, I live in the inner Sunset, and until one of my neighbors made the effort to get information through the Sunshine Ordinance, I had no clue what was going on in the Formation Committee meetings. Now, admittedly, those were open, and there were, healthy attendance for both the pros and the cons, the overlapping committees, maybe everybody's ideas came out. But I think that there is a lot at stake here. It's not just this one formation committee. You get one done, you're on to the next one. Why is there an employee in the Department of Public Works whose sole job is to create green benefit districts?
Thank you, ma'am.
So you need more information.
Thank you.
Please take the time to hear this.
Thank you, ma'am. I'm going to ask the maker of the motion if he would, it would be in the negative. If he would, since he voted in the negative, if he would rescind, would reconsider the vote for the purposes of just providing a motion to continue so that we can have further allow. It's obviously half of this body is not sure. and the other half is somewhat is sure.
I only made the motion because it was changed from the motion to not find jurisdiction.
I understand.
And we have, I have to think about it, but as a body, since I've been here, we've always needed 6 votes, and we have never reconsidered a vote, even when we've only had 6 people here.
It's always the first time.
When I consider it totally unfair to the public.
Yeah.
So,
Okay.
Through the chair, is there another way we can tackle this problem of
Not unless it gets reintroduced.
because honestly, we haven't really gotten to the merits of the case, but the thing about videoing, because you guys weren't there at the committee.
Don't discuss the substance of it because you
That's-
can't. I mean,
can we not take this on independently?
The question, again, the question, as former member of this task force, and he had pointed out, and advice from our legal counsel, is that an action to determine jurisdiction is considered substantive. Okay, requires 6 votes. Okay, we didn't get 6 votes. Motion has failed. My only question is because it was so close that there is interest in hearing this case. The question is let's say, I wouldn't say that. There's interest in further determining or trying to figure out if there is jurisdiction. Would be open to it? You can.
Yeah, I wouldn't, but I'll go to where Member Wolf went earlier. If the complainant brings the complaint against DPW, we could have more discussions on it. But that's a separate complaint.
Okay.
But otherwise, I think this is
Okay. So in the interest of time, and so we can move ahead, we're going to leave. I'm going to declare that we leave it at that. The motion has failed. We have determined that we do not have jurisdiction. And let's move to the next item. I thank you all for attending and your indulgence in this matter. Please call the next item.
Item number 7, file number 18049, complaint filed by Robert Smith against the Fine Arts Museums of San Francisco for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner.
Okay, so looks like the complaint committee heard it last.
We did, and I was chair, but I know this was a follow up to several meetings, and we requested the documents. And I believe Member Martin was the one person that was here with me, and I don't recall much about that meeting. Do you? Yeah.
Testifies not here.
Member Testify wasn't on this iteration of the complaint committee.
I got it.
It was me, Member Kate, and Member Martin.
Can we just go by the notes?
Yes, you can. Member Hinson, is this the? Because I'm trying to refresh my own memory. Where we're trying to make. There's communications between the Museum of Fine Arts and the nonprofit entity that
The COFAM?
Yeah.
COFAM, yeah.
Okay.
Yeah.
I just have a question. Was this found to be in jurisdiction?
I believe so.
I believe so. A few meetings ago, yes.
Yes. 6 iterations ago.
Okay. Well, it's been in committee. This particular one has not. Oh, it does.
No,
okay, it says it has. Okay.
It's been
Right.
referred back for more documentation
Got it.
several times.
Okay. So, let's see. Come here. Okay, I guess what we need to know is what did the complaint committee find
Yeah.
at this point, so we can move the case forward.
We're looking.
I mean, it got sent back to committee.
We're looking that up. I don't remember off the top.
According to the notes, this was September 25th in complaints.
Yeah.
They just moved the matter to the call of the chair and.
No, but it was. If you start at the top of that, it's on July 17th. The complaints and amendments determined
found
jurisdiction,
right.
and then August 28th, the complaint committee continued the matter. I'm not quite sure what's going on there.
And per the notes, I think that Ms. Powers was here, and she stated that she had provided public documents to Mr. Smith and that she had requested search terms for Mr. Smith to narrow up the scope of the document review. I think there was also questions that were to be sent to the city attorney regarding what does and does not apply to COFAM, and she was awaiting a legal opinion.
Right.
Just the staff notes, and moved it on.
Have staff notes. Oh, there it is. Never mind. How it just popped up. All right. Okay, so I guess we're ready for a full hearing.
I think so.
Right?
Yeah.
Okay. All right, so Mr. Smith, 5 minutes.
Good evening. I've been here so many times, I'm trying to recollect what I haven't talked about. I'd like to mention tonight a red herring and a smoking gun. The red herring is the notion that this museum is not, or these museums technically, are not susceptible to producing documents to citizens. The ground they gave for this is the following. In my jargon, there are 3 silos. Silo 1 is the museum. Silo 2 is the managerial entity they've hired to run the joint. And Silo 3 is the fundraising entity. They take the position that silos 2 and 3 are not susceptible to citizen requests for public documents. Now, this is not so because the statute says it isn't in the first place, putting aside common sense, because the deputy city attorney gave you an opinion citing authority that says it isn't so. And beyond all else, my request was to Silo 1, the museum, which is clearly a city entity. It's a department of the city. And it shares everything that silos 2 and 3 have. Why? The employees of all the silos are essentially employees of the city. And passing that, I sometimes find it difficult to deal with what to me seems truly a red herring. I asked the museum for the materials. They said, we're not giving them to you because Silo 2 has them, maybe Silo 3. They share the same servers, the same computers, the same personnel. It is a red herring, And I come to you today with a smoking gun furnished to me 2 days ago. Sorry, I may need a little help here. I just want to see this display this document. By the museums, they've revised the document they gave me 5 months ago, unbidden, with no apology and no explanation. And here is the document. Can we get the whole thing on there, Madam Clerk? You can see this has been changed. This is a request to somebody, or an answer to somebody else's request, and it says...
Mr. Smith, I'm going to have to ask you to please speak into the microphone because it needs to be on the record. You can point to it.
Thank you for reminding me.
You can point to it right in there. Yeah.
Okay. Yes. Thanks. In any event, you can see they've changed it from "we have no responsive documents," or records rather, to FAMSF has none, in order to dodge producing the documents required by the citizen, right? And then this questioner, this member of the public says, you've assessed and collected $10 millions of dollars in special exhibit and private rental fees Silo 2 has. So I want to see this stuff. And they say FAMSF has no responsive records. Now, why did they change it? The CFO changed it, actually, for exactly the reason we're here tonight to discuss. Namely, that if they said we, it would obviously include the entity that they deny. Not sure why this isn't coming up. Can you give me a hand, please? It's pretty that they deny has it. So they've been very careful to change the language, and you can see his memo changing the language. Well, I hope you can see it.
No.
Other way.
Turn it the other way, yeah.
Or lift it.
Turn it up. Put it up. There you go.
Okay. The only requirement is that we give them FAMSF records. My changes are in green. You saw his changes.
No problem.
And he's the CFO, right? And then they've redacted in what I got this line with no explanation for what they have taken out. And at the bottom, they've changed it to say, if you should require from what the normal would be, if you should require any additional information, let me know. They say, no, don't say that. Say additional FAMSF records so we can give her what we want, not what she has every right to have. So I guess I ran out of time, but I wanted to show you what's behind this really shell game. If we don't get these records from this museum, it's a travesty. I'll discuss separately the other request to see if they got funds from Saudi Arabia for a recent exhibition, which is now closed. But please consider what you just saw. Thank you.
Thank you. Are any persons or witnesses to provide any facts or evidence on behalf of the petitioner or the complainant? Seeing none, respondent?
Hello, Melissa Powers on behalf of the Fine Arts Museums of San Francisco. Hello? Okay. Yeah. Melissa Powers for Fine Arts Museums of San Francisco.
And Megan Bourne from the Fine Arts Museums of San Francisco.
Okay, I'm going to watch the clock very carefully because I'd like to make one point relating to this, which is a shame to take away the 5 minutes from this. Those documents Mr. Smith has always had. They were from a request from September 3rd that are not part of either 18049 and 18083 because one of the complaint committees had said we needed to fix redactions we had given him, and I realized that I hadn't given him those specific ones. I resubmitted them to him with names allowed. He's had these documents since September 3rd, or since I originally gave it to him, as is. So, and again, they are not part of either one of these two complaints. So to go to the merits of the two complaints that are actually here tonight, I'd like to say we have never disputed that Mr. Smith is entitled to city records. What we have stated is that that is what our authority is. That is what the Records Act applies to. So to use his own, I guess, paradigm, if Silo 1 means that there's an email from a citizen to the director, from the citizen to an HR who is a city employee, that's a city record. There's no doubt about it. He's saying he now can tap into Silo 2 and Silo 3, which is COFAM and FAMF. What the city attorney provided, he didn't provide an opinion. He provided elements. And two of the elements, COFAM nor FAMFF, trigger. Are they created by a legislative body? Board of Supervisors? No. Do they receive money from the city? No. They are nonprofits who have an MOU with FAMSF per the city charter that they are allowed to do. So if we start saying, they are now applying to the Public Records Act, then you're opening a whole new. We agree that he's entitled to the city records when city employees retain those records, use those records, create those records, not if they are solely a record of COFAM. And so when you look through the record where we have told them that, it's because it's not a city record. Now, regarding the one that is outstanding that we have been going back and forth with Mr. Smith over those hearings is the large request for correspondence between FAMSF and COFAM. We have asked him to narrow it. He narrowed the time frame, but we are asking him to narrow the scope. And we tonight are requesting that the task force direct order, I'm not sure what verb you use, Mr. Smith, to provide at least some search terms, or at least start with that, because even we have over 425,000 emails in the server for those 2 months. And if you were to even only go down to the city employees, that's over 70,000 emails. Every time we give Mr. Smith something, he comes back with, what about this? What about that? Even when it actually is legally correct to redact it and to go through that with 70,000 emails when there's no scope, I don't even think that that's in Mr. Smith's best interest. I think if he provides us some search terms, that is what we are asking, and that, we have a small IT shop that can help it. We have a small pool of resources to review these documents. Under the California Public Records Act, Section 6253.1, a request should be focused and effective. He doesn't even name people. He says COFAM to FAMSF. What does that mean? How do we find correspondence between an entity and an entity? So I have a minute left. Do you have anything to add?
I don't really have anything to add other than just to reinforce the request that we have some search terms, some parameters for this overly broad request. We have been, we tried to chunk it out in some way. It crashed our server, and we printed out stacks and stacks of things to go through, and it's just an impossible task to really try to grapple with this. If we have a specific topic, specific search term, we would request to at least start there. Thank you.
Hey, ma'am.
Megan Bourne, Bourne.
Just waiting for the clock.
I know.
Whether you're ready.
I started to walk away, and I was like, oh, no, that's not going to happen.
Yeah, thank you very much. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Seeing none. Okay, members. Member Canada.
For the respondent, what functions do Silo 2 and 3 perform for Silo 1?
Silo 2 and 3, which is Corporation of the Fine Arts Museums of San Francisco, and the other one is the Fine Arts Museums Foundation. One supports to do operations, fundraising, and the other is mainly for our art acquisitions and investments.
Yeah, the Fine Arts Museums Foundation manages the foundation funds that are privately donated to run the museums, and the majority of it does go for art acquisitions. I would also note that in Mr. Smith's opening remarks, I think at one point he said that Silo 1, presumably FAM, hires the other two entities, and that is not the case. They, in fact, the COFAM and the foundation support the fine arts museums of San Francisco, providing operational support and funding for art acquisitions.
He also mentioned that all the employees in all silos are city employees. Is that true?
That is not correct. I would say that at the what it takes to run the museums is approximately in the neighborhood of 200 city employees, the majority of those being our security staff, engineers, and admission attendants. And the rest of the museum employees are employees of the Corporation of the Fine Arts Museums. And those are curators, educators, conservators, our marketing department, our finance department, et cetera.
So the corporation is silo too?
I'm not sure that that's how Mr. Smith sees it, but we have Fine Arts Museums of San Francisco, Corporation of the Fine Arts Museums, and the Fine Arts Museums Foundation.
Okay, and so the Corporation of Fine Arts Museums paying their own employees out of what type of funding? Public funding?
No, privately raised. We earned and contributed revenue. So
privately raised in behalf of the museums.
Mm-hmm.
Okay, thank you.
And for those that may have not yet seen this issue in the previous complaint committees, the MOU is, I know that it's, some things are repeated in the package, but on page 1011 is the MOU between the three organizations.
Member Josh Wolf.
COFAM, the Corporation for the Fine Arts Museums, is that a nonprofit or a for-profit entity?
Nonprofit.
Even though we think corporation and think for-profit, it's just
it's a nonprofit corporation. Yeah.
Okay, great. Yeah. And then, so both of those, COFAM and the FAMF are both nonprofits. And does the city serve? Does the city or a city appointed member serve as on the board of directors of either nonprofit? Sure, I'm asking. So both nonprofits presumably have a board of directors, and I'm asking whether the city has a role in selecting who serves on those board of directors in some fashion, whether it be like the mayor's liaison, or the city appoints someone, or the city names someone, or anything, or are they wholly independent from the city nonprofits?
Well, we have two ex officio members of FAM, or no, but that's our city board.
Right.
So none of the board of directors members are connected directly to the city.
And actually, ex officios are not allowed in California anymore.
Oh, really?
Since 2012. Okay.
That's all I.
Okay, Vice Chairman.
Because we have them.
We do.
No, but we're a government body. We're nonprofit.
Oh, okay.
Nonprofit.
I thought you were, I was like,
Yeah.
Quick question. I'm not sure if it's in our package, but we had asked in previous meetings for you to provide us a copy of the MOUs with Silo 2 and Silo 3.
Page 1011.
Thank you.
So I have a question for DCA Price Wolf. In 12L, is that this was some of the discussion we had during the various complaint committee meetings of whether the nonprofits, because they have an MOU with the city, whether 12L is applicable or not. 12L, under 12L point 3, subsection E, has its own definition of what a nonprofit organization is, and this is a constitutional construction, more technical question, because of the use of a comma. Nonprofit organization shall mean any corporation formed pursuant to California Corporations Code Section 5000 et sequitur for any public or charitable purpose, and or any organization described within 26 U.S.C. Section 501C, comma, which receives a cumulative total per year of at least $250,000 in city-provided or city administrative funds. So is it receiving $250,000 for a 501c3 or a California Corporations Code Section 5000, or is it just the 501c3 receiving the $250,000? Because there are
Your
some
question is whether I think the 250,000 modifies both the first and second part of the
right,
sentence.
yeah. Just as it's a matter of legalese.
What I happen to think.
Well, I'm asking your advice.
You know, I think it's a tough call. The way let's see, nonprofit organization shall mean any corporation formed pursuant to this corporation's code for any public or charitable purpose and or an organization under this federal statute which receives
just confused
at
by
least
the use of commas.
$250,000.
I mean,
I wouldn't feel comfortable answering that without reading if there's any case law on it. I could tell you, just looking at the statute, it looks like the $250,000 might just modify the second half. In other words, just the 501Cs. But I don't feel comfortable making a recommendation without looking at it in the context of the whole statute and maybe if there's case law on it.
Right, because it was actually in DCA Cola's memorandum that he poses. We asked the question of whether the complainant utilized 12L. That seems to me kind of a presupposition that this is. I mean,
I believe he asked that question previous to him issuing the case factors.
So this is August 23rd.
Not issued to us until January 16th.
Okay. Wait a minute. But this has been in play since August.
Correct. But my understanding of the way things sort of progressed, we sort of were in that 12L discussion, and that was what was sort of issued as the governing memo from the advising attorney. And then, I mean, my just experience or what I thought was happening was the issue sort of became more of, does the Public Records Act apply to these nonprofits versus the 12L issue? And that's why that we went from the 12L issue to this issue. That was my understanding.
Okay, so. I guess I'm not sure that the I'm not clear whether the 12L issue has been decided yet or not. Because it's just a different process. That's all.
And to clarify regarding, because I thought it came up even earlier tonight, and I think once when we were in front of you, Mr. Chairwolf, was again that neither COFAM nor FAMF receive any city funds.
Okay. Because the reason why I brought up 12L is because under its definition of contract, it includes without limitation a memorandum of understanding. And so that's why I was asking for the purposes of this nonprofit whether 12L would apply based upon the definition of nonprofit organization for 12L, and it just technically is a little confusing to me. I don't know if anybody else has any thoughts on that, because it would help guide us to in moving this forward as to which process is which, whether it should go through the 12L process or through our process, and whether those nonprofits, however independent they may be, having a MOU, still have an obligation under some form of sunshine. So that's the question. And the other question is whether the documents that are being asked for and have been presented, whether we're beyond that point. Yeah.
Through the chair, the other case that was similar to this, I don't remember if the Friends of the Public Library are not profit.
Yes, they are.
They are. Okay, so we have a case that has not been resolved.
Right.
That was sort of similar to this, and we were trying to make a decision of whether the Friends of the Public Library to follow the entire Sunshine Ordinance or just the one stipulation of reporting funds?
The difference is they have a lease because they have a space in the library. And because they have a lease, the ordinance has specific language with regards to that, and then that is what still needs to be clarified as to the relationship of that lease. So I hear what you're saying. It's a little different because the ordinance provides a little more substance for that particular case. I think it's more like the Bayview Opera House.
Okay.
I think that's what this is more like in that, because they're the I think it was it Park and Rec?
Right, because they receive the funds. It's not that the city is giving them.
Right.
The funds come from an outside nonprofit.
That's right. So here it's for 12L to operate the nonprofit organization. I don't know if you want to, it would be somewhat onerous, but to get an opinion or some additional advice from our legal counsel to whether COFAM is a nonprofit organization as defined under 12L. I mean, he's not comfortable answering that now without reviewing some case law or what have you. But as far as the way this sentence is organized, or the question is has enough information already been provided to Mr. Smith that goes beyond what 12L would have provided anyway? So that's a question I'm putting before everybody to see how we should proceed. I'm just trying to get a procedural guide here somehow. So anybody? No, Mr. Smith wants to say something. I'll allow it. In the microphone, please.
I'm sorry. They promised you they would turn the records over in response to my requests. They have not done that. This is on the record of this very body, number one. And number two, someone asked about the boards. The boards are the same, except for maybe one or two people. They're the same board.
All right, so let's see.
They're not the same board, and there is the authority for one of them to. They're not the same board.
So I'm just going to try to recap a little bit because this goes back, 8 or 9 months. On August 28th, the complaint committee requested from you information regarding the legal and contractual relationships of the two COFAM.
Correct. So we provided the MOU, and then we also presented the PowerPoint presentation,
right? Okay.
Which is also in the record. I can skip. I can probably find it real fast.
Okay, that's okay. I'm just making sure what was asked for was received. Okay, so what let's see what information is there any information that's still being withheld?
Well,
let's start with that.
I'm hesitant. I don't want to accept the verb withheld in the sense that we'd like to work with Mr. Smith for him to, I guess, fine tune or make it more specific, his request. So in regarding complaint 3 of I think it's 18049, it's kind of two parts. He wants COFAM to FAMSF and then FAMSF to FAMF. We were able to kind of work through FAMF to the second part. The first part, Mr. Smith, not to speak for him, he's saying he's gotten none of that. What we're saying is that we understand that the city is a second part of that equation. but there's no terms. Like I said, there's no people. It's, I don't, how, that go to our IT. Can you find correspondence between COFAM and FAMF? We like people, we like search terms.
Okay, so, all right, so Mr. Smith, let's see if maybe we can come to some conclusion here at some point, okay?
Right. Can I just say one thing
Of
based
course
on
you
what
can.
she said? Is
Sure.
that okay? Fundamental to what you're doing and to freedom of information in this country is that it's not up to them what they give me, what I request. It is up to a journalist, a reporter, a lawyer, any citizen, what he or she requests. It's not for them to decide. One. Two, they've made no effort, virtually no effort, over more than a year to fulfill the requests. That is, in my mind, remarkable. And I say that as a former investigative reporter in the Washington Bureau of the New York Times, as a government official on the other side of this in the Carter administration when I was special assistant to the Attorney General and head of the Department of Public Information and Justice Department. I have never personally thought that I would see anything like this. Folks, if you'll indulge me for 1 second, I asked the Department of Defense when I was covering the Pentagon for the Times, I need to see what the Pine Bluff arsenal with all these chemical biological weapons looks like. Can you show me? And 2 days later, I had a manual with pictures of Pine Bluff Arsenal from the Department of Defense about an extraordinarily sensitive topic. When I covered the FBI under Mr. Hoover, I asked for a copy of a magazine, the FBI magazine for in-house employees, that is, for the agents. They didn't want to turn it over, and Hoover stood firm for 1 week, and then he gave it to us. Now, think of those things, and then think about what everyone thinks of as a city museum here. City museum, they've got an entity taking in all this money, which they won't account for because they say it's not public, and there you are. Yes, sir. How can I help?
Thank you. No, you wanted to make a comment. I provided you that opportunity.
Sorry, I didn't mean
Okay.
to go off on a. If I can help you, I'd be most I'd be most happy to. There's another. Do you want me to do the Saudi business at the same time?
No, because that's a different case.
Yes, I know.
Member Joshua.
Right. I'm trying to walk through this email sifting issue because I think that if we can figure out a way forward, it's better than working in circles again and again. So this question is first for Mr. Smith and then maybe for the museum folks as well. So we have COFAM that you've requested all correspondence between FAM and COFAM. That's correct, right, Mr. Smith?
No, I didn't know about silos 1, 2, and 3 when I made these requests.
This is request number 3, so he did request.
Well, excuse me. May I just finish and then you can say I'm wrong. I didn't know there were 3 entities when I started. So the first and largest group of queries, or whatever one wishes to call them, requests, public record requests, simply was addressed to the museum, which is what I knew existed. And then, down the road, they raised as a defense that the museum consisted of these 3 parts, 2 of which they argued, in my mind quite unsuccessfully legally. Ask your deputy city attorney. He provided a memo on this subject, and the memo is quite clear that these other 2 are immune from public scrutiny. If you say they're immune from public scrutiny, it means the museum's immune from public scrutiny. Did that answer your question, sir?
No, not at all.
I'm sorry.
So I heard earlier testimony that of your request for correspondence, there's a pool of about 400,000 emails that has been trimmed down to 70,000 emails, and the museum folk are trying to get you to limit that to a search term to minimize the number, and they've stated that they don't have a sense of what the people you're looking for. And so where I was starting with my question was I was trying to figure out if the COFAM, the people associated with COFAM, all have emails with the same subdomain, because that makes this a lot easier. And if not, whether if they were to provide you with a spreadsheet of the from and the subject line if that would allow you to identify which records you needed.
The second, Mr. Wolf, would be very helpful. As for the first, I don't know about subdomains and all that. They have one server on which all of this stuff exists. Therefore, it is completely accessible to, and in my mind, the property of the museum, as well as this other entity. It's one server, one batch of information, however big it is.
All right, thank you. If I could speak to one of the representatives. We just heard the suggestion that COFAM, FAMSF, COFAM, and then what's the third one? And the COFAM Foundation are all utilizing the same mail server, which seems hard to believe.
Yeah.
Is that true? Do all of these groups of 3 different entities all share the same portal to send and receive mail?
Well, FAMF, there are no FAMF employees at the museum. So there's FAMF trustees, and those are people outside. So the real COFAM employees and city employees all have the same kind of at famsf.org. So, and there's one server which was purchased previously, originally with COFAM funds, and then upgraded through COFAM funds. So there is one. So that is part of the issue in terms of it's not like we could search for, even go COFAM to FAMSF. We're already starting with just FAMSF.
So whose server is it? Is it COFAM server or FAMSF server?
COFAM. It's funded through COFAM.
But it's owned by COFAM, is what you're saying. So so essentially we have an issue where you have city employees using a private email server. That is what you're saying.
Yeah. Well, that MOU allows for COFAM to support the operations of the city. If you look at our attachment 3, is the city budget to FAM, and you can see that it's a limited budget. So things to do the daily operations as allowed through the MOU comes through COFAM funds.
But it sounds like both Mr. Smith and yourself are saying that when it comes to correspondence, there is no fine line between what's city correspondence on the email server and what's private correspondence on the email server.
What we're saying is that we have city employees. That would be the FAMSF side of his equation of COFAM to FAMSF. To find all of those emails, we would then have to manually put in every city employee's name to find all of their emails. And at last check, there's approximately 70,000 emails in that 2-month period belonging to city employees.
I mean, I hear that, but I'm still stuck on the fact that we have a private email server that's maintained by COFAM that is also the server that your city employees are using. Like, I'm having like Hillary Clinton email memories in my head, and obviously it's not the same thing, but there still is this issue of private emails and public emails not being discrete. And I'm beyond that. Let's just set that aside for a second, because we're not going to resolve that. Why is the resolution not to provide, because you have a list of 70,000 emails. We've trimmed it down. It started at 400,000. A spreadsheet with the froms and the subject line, which would allow Mr. Smith to identify what emails he's actually looking for.
Of the 70,000 subset?
Yes.
Well, sorry, this is the first time it's been proposed. I mean, we can obviously talk to our IT people, and I mean, I can't speak for them. I don't know why they wouldn't be able to pull the subject lines. I don't know. I don't want to speak for what their capabilities are in terms of how you can pull subject lines versus users. And to his point, in terms of his previous experience and requests, like I said, even under the California statute, it talks about a focused and effective request, and this is not focused and effective.
Right, but in this case, we have a former reporter, a current reporter, I'm not sure, who's looking for a needle in a haystack. And so, yes, it is on on him to work to narrow down the request, and it is on you to provide what you're looking for. Now, a search term may not allow you to find the needle in the haystack, but a list of what all the emails are is one of the easiest ways to sort of, it's essentially an index of correspondence records.
Right.
And so it sounds like that may be a possibility, but you don't want to say it is until you confirm with the tech, your tech team. But I definitely would like to see it explored whether that would work, because it sounds like that would satisfy Mr. Smith. That's it.
We can do that.
Could I just add,
Sure.
Addressing your concern about the emails of city and COFAM employees. The city does not provide any funding for the museum's. Over the years, the museums used to be entirely supported by the city, and just because of the nature of how expensive it is to run a museum and how much cities have to cover, they have scaled back over the years. So in broad terms, the Corporation of the Fine Arts Museums provides all the operational support for the museums, including email.
Right. I understand it in practice.
But I get your concern.
Well, my concern is that, say, Mr. Smith, after the end of this process, isn't happy with where the Sunshine Force resolves, or you refuse to comply with our order. Either way, this ends up going to court over emails related to a server that has both private and public emails. It seems to me that if this went to court, you'd have to turn over this entire server that has your private emails on it in order to verify any claims that Mr. Smith might have about those emails. So I understand that money's tight and this sort of thing, but it does seem like forcing the city employees to stay on city servers has a certain benefit to it. But I'm not sure that's even at the meat of this complaint, so we should probably move on from that. Go ahead, Mr. Smith.
It may be helpful for you, Mr. Wolf, to have a context. If a reporter or a lawyer looks at this museum, he or she sees a museum which has had a different director every year for the last 8 years or so, right? He sees a museum which has the board of directors having the former city attorney of the city quit because of its lack of transparency, monetary transparency, financial transparency. So you say, what is happening in this museum, for goodness sake? And you, of course, wonder. And that wonder is fueled by a head-on refusal to turn over documents, which I think I described with specificity. I'm looking. But with all respect, and I appreciate your effort to help, honestly, I do, sir, if they give me just the subject matter of the emails, I don't think we're going to do it, because you'll see when we get to the Saudi request I put in, which is rifle shot narrow, the heading on it is subject notice of new law related to April 2 and so on. It doesn't say something about Saudi Arabia. They won't even tell me whether they got Saudi money to fund an exhibition on Muslim fashions they just put on, in which they managed to skate through without giving me an answer. That's fueling this, to allow them to set the terms of what they're going to give anybody, any citizen, not just me, is dangerous terrain for a free press and others.
Thank you.
Member Canada.
Through the chair. Mr. Smith, don't go away, please.
It's the first time in a long time anybody said that.
Do you want the 70,000 emails?
I'll take them. The usual tactic in this situation in litigation, I was also a trial lawyer, God help me, is to give the person so much. Well, you know. Okay.
Okay, respondent.
Please approach.
Please.
Ms. Powers.
Will you give Mr. Smith the 70,000 emails?
Well, it still doesn't erase the burden of still having to review every one of those emails. So to say that we won't, because it still goes back to, so I'm not saying,
okay.
No.
They're all public records, correct?
Correct. So
you can give them to him on a rolling basis. You don't have to give him 70,000 emails at once. If a member of the public is asking for them, you should give them to him.
Right. So that's what we're here. We're asking for search terms. If there isn't search terms, then we're going to have to go back to IT. And they told me that they're going to have to manually put in every city employee's name and every particular equation that they could to find out every email that they're on.
Wait, I thought you said you whittled it down from 400,000 to 70,000.
When we previously discussed this with the IT, that they gave us that between those 2 months in question, there were about 70,000 emails on the server from city employees.
So provide them with those.
And I think, we can come up with a reasonable, Member Wolf is here. What do you think is a reasonable timescale rolling basis for 70,000 emails as far as, chunking it?
I mean, those 70,000 emails are the entirety of the emails that this department sent in that period. Some of those emails, there's no reason that they need to be reviewed to ensure that there aren't confidential information. But some of them there are, and I have no idea what segment of the 70,000 need to be actually read before they're turned over. That was why my suggestion of starting with the 70,000 subjects and from lines, like essentially export a spreadsheet, and then you can do search terms on that, identify I want items 4 to 5,000, blah, 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 and then you can limit that. Go ahead.
I absolutely would have to review those because one of the city employees is the HR director, and I'm not going to just hand over to Mr. Smith emails about personnel. They have to be reviewed.
But those emails should be identifiable because he's the HR director, and you know them.
Right. I'm just saying. Then
what I'm trying to say is to get a process started to give this man his information.
Yep. I mean, I personally think that this suggestion would help even more to help give it to him, but we can go back, talk to IT, but to Chair Highland, is that correct, sir?
Acting Chair Highland, yeah.
That we have to, I've read in the rules about like within 5 days. I mean, it's just.
No, for cases like this, you're not the only city agency that has had these voluminous requests. And what we do is we set up a rolling basis of what's reasonable. So I think what would be a good first step is, you've identified these 70,000, so at least he knows the subset of what he's getting. And then you can say, okay, in the first week, we're going to give you X amount. The next week, this. The HR director's emails are going to take longer for redactions. And again, you have to still send them, but with the redactions. And then you can reserve the more complicated ones to the end. But he still needs to see what he's going to get. And he should get all 70,000 emails. And the ones that are redacted, you need to also provide evidence as to.
And I will say, you don't know where, and I will, because even when you're dealing with, let's say, a lot of our city employees are security guards, that will be a big chunk, but they're going to be talking about maybe their shifts, or someone has to call out sick, or somebody's this, somebody's that, and that, even though it's a city, still has to be. So I don't want to say that any group is going to be easy. Every group before I hand that over, because they also have a privacy right, is going to have to be.
That's fine. And perhaps you can work with Mr. Smith. If you can say, all right, here's the 70,000, and maybe he can identify, all right, I'd like these first, and then you work on the next batch. But you should be able to set up a schedule where, that can be a thing. I mean, we've done this many times with other departments for bigger requests. Mr. Smith, you had a comment?
Just a question. Are we clear that doing this by subject line of memo or email doesn't work because the most valuable material clearly doesn't appear in the subject line? Usually it's buried someplace deliberately, often deliberately, not always, sometimes unintentionally. So the subject line business doesn't work. Secondly, I'd feel remiss if I didn't point out that we're now 1 year and 2 months into this, and they haven't given me the stuff, even though they promised you. I mean, there's no question here. They said we'll give it to them on a rolling basis. They haven't rolled. Mm-hmm. So you'll forgive me for being a little untrusting. I would welcome your telling them a schedule, but not the kind of schedule that's prevailed over the last year where nothing has been rolled out. There's not even an issue here for you in a meaningful sense, folks. They promised to give me the stuff. It's on the record here. They told you that. They just haven't performed at all.
Right.
And not only have they not performed, to the minimal extent they've performed, they've used a redaction system that surpasses logic and belief. I will show you when we come to Saudi a couple of redactions. There's no rhyme or reason to them.
Let's deal with Saudi separately.
Okay, later.
Since
But I am worried about redaction because there doesn't seem to be a legal standard in use about what's redactable.
Okay. Have we done rebuttals yet? Not yet?
No, let's do rebuttals.
Okay.
Unless,
I agree. So, respondent, you get a chance 3 minutes to rebut for rebuttals. If you have anything further to add.
I'm not sure that I have any further information to impart, but in rebuttal to Mr. Smith's expression of frustration, we similarly have frustration, and I do appreciate. I feel like in this meeting tonight we have actually made some progress towards getting to a way that we can actually manage this request.
Thank you.
Appreciate that.
Ms. Powers, anything to add?
No, it's, I guess, maybe more of a question. Are we supposed to work with Mr. Smith to come up with the schedule, or does someone do that for us?
You'll work with Mr. Smith, and then please copy our clerk on what you agree on and the time frame and the amounts of emails you're going to send. And, we can discuss what would be reasonable, but I think the two of you can probably work that out. All right. Thank you. Mr. Smith, yes. You have 3 minutes for your rebuttal.
Take 3 minutes.
Okay.
I really need some help here. It may not appear so because I'm in a circumstance where I'm not getting anything. So maybe it appears as if I'm firmer than I mean to be, but I want the stuff. And I would help it if you would try to set some sort of schedule because I think not to do so is going to leave me in a circumstance where I'm quarreling unhappily with them about a reasonable schedule, given the fact that I've already lost a year.
Okay. One quick question. What format, these are obviously going to be condensed zip files type, if you got, let's say...
electronic format.
10,000 in a batch over 7 weeks. Is that reasonable?
I'm sorry, 10,000 in a batch.
10,000 a week for 7 weeks.
Yes, of course.
Is that realistic, members?
Could I ask through the chair, another question?
Sure.
Mr. Smith, are there, there was mention of lots of security guards and people who deal with admission. Do you want those too? Could we maybe then, would you say that they could exclude those?
The security guards, sure.
Exclude so I don't know, maybe that takes off a nice chunk and that might
HR.
Exist.
No, because I don't. This museum has had a lot of HR problems. I think.
Okay.
Can I? But I'm not sure about the How do we get the 70,000? What defines the 70,000? Please help me.
Can we pause his time for a minute because this is a conversation, not his rebuttal.
There was they said that they had 70,000 in the 2-month period you asked for. They said the server has 400,000.
Ms. Powers, you can explain.
In the 2-month period you asked, there were 70,000 emails.
Oh, so that was the beginning slice. I whittled it down to a short time period. They've got 70,000 for that whittled down time period.
Yes.
I did try to accommodate them.
Yes. That's where we're at right now. Ms. Powers, we'll come back to you, Mr. Smith.
Right. So, and we can provide, because in the PowerPoint that we provided in one of the previous complaint committees, we have a list of who they are and things like we talked about museum guards, admission attendants, things of that nature. But to the point, Mr. Highland, of the numbers you're proposing, this is where we put in our original submission. And I understand that this is not relevant to the question of whether he's entitled. It goes, though, to our ability to fulfill it.
Right.
Is that it's one person who's going to be reviewing those emails who also has other profiles that support the city, such as like when we have a board of trustees meeting.
Right, I'm going to interrupt you there because several months ago we asked this process to start rolling. It hasn't happened. So this one person could take 10,000 emails which required the least amount of review and redaction, send those to Mr. Smith, who can start reading them. That'll keep them, get them started, and then they can go and batch by batch release the next batches. So you need to produce at this point.
Right. Well, what I think I'll do, if it's okay, is resend him the chart of what are the positions of the city employees and see which ones he's willing, if any, to eliminate.
And or prioritize.
Yes.
Okay.
And
I think that's fair.
And go from there.
Okay. Mr. Smith, please, we'll come back, finish your rebuttals. Cheryl, if you could put the time back on.
I can provide a list right now of a half dozen topics that I would like to see the documents concerning.
I think what they're offering is they can provide you, like, forgive the pun, Mr. Smith has 300 emails, Mr. So-and-so, the city employees and the positions and the emails associated. So
right, but I mean, I thought there was another way to slice this down. I can give a half dozen topics that I'm keenly interested in seeing.
Search words? Yeah.
Well, I don't know if you, that might be a bit tight, but they must have some organization there, a filing system of some kind. I mean, it can't just all be mixed up entirely like vegetable stew or something.
Right.
So I can tell them I want to see about the everything relating to directors being dismissed or quitting.
Yeah, that could be your top priority, for instance.
Ditto board members being forced to quit or quitting. All correspondence about it.
Yep.
Member Josh Wolf.
We've been talking about a lot of different ways to try to get the information you're looking for, and based on my experience in digging through large piles of data, I believe that rather than identifying these query-like sentences of topics, if you were to make a list of 50, 60, 70, 80 words that aren't thes and us, but are things like quitting, termination, Saudi Arabia, all of the words that you think could possibly show up, is easier to pull anything that comes from those words than these sort of broad-based sentence questions like, did anyone relate to quitting? That's not something that can be easily typed up. But if you give a list of even 150 words, they can give you the emails of every email that has that word at all once in it.
Difference between a technician's approach, an engineer's approach, and a journalist's approach or a lawyer's approach. I can't give them search terms like that. I can tell them if they have files. They must have some filing system. What files I'd like to see.
I understand.
They must have some filing system, right? Everything can't be one jumbo mess in the sky there.
I mean,
not everyone files their emails.
But an institution?
Yeah.
Yeah,
an institution.
You go back and you search, and who to, from, search.
Okay, I apologize for my lack of expertise.
Okay, thank you. All right, that concludes rebuttals. We're back in front of the task force. If anyone wants to provide any, entertain a motion, and then with that we can have instructions pertinent to a rolling schedule of emails for Mr. Smith. Member Wolf?
I'm not sure whether I'm seeing a violation, but in terms of a process, it seems like basically in either the next compliance and amendments or EOTC, this should be on our schedule to go what happened in the last month, what happened in the last month and a half, whatever it is.
Definitely.
I haven't parsed this well enough to understand the actual violation issue, and I'd almost be more inclined to bring that back up later once this is all sorted out, because right now what seems to be most important to Mr. Smith is figuring out a process to get his records, and we would need to continue litigating this to try to figure out the violation right now.
Chair Wolf, may I respond to that? In response to that, I think we need to get on the record the fact that the respondents have now admitted these are public records, and there's some, timeliness issues there. I think at the very least that's a violation, and then also work on a schedule of getting those documents. I think.
Do you have a motion?
Sure. 6725. It's been 14 months and going.
I'll second that.
It's not a 6725 request.
We can still add that, though. If that's
No, you can't.
Yes, we can. We can add different.
It'd be
parties.
6721 instead of 6725.
Yeah,
That's correct.
6725 is a process available to the public to use. It's not for us to.
Apologies. So 6721 amended.
Mr. Highland, you mischaracterized my position. I don't know if I'm allowed to say that at this point. Of course, I want these documents, but I also would humbly, respectfully ask you, this group, which it's your duty, to find there was a violation by this museum of this law.
That's what I'm trying to
What
do.
we're doing.
We're doing both pieces. So, right.
I did, but we probably want a letter attached to that.
I think it's probably E again. Let's see. Looks like E is fails to claim. Yeah, I think E fits because they were claiming it wasn't public, and we're determining that it is.
Works for me.
Okay, so who's making the motion?
Highland made the motion. I seconded it.
Okay, so moved by Member Highland, second by Vice Chair Highland, second by Member Josh Wolf.
Do we need to add to the motion?
You want to refer it
What
to?
referral to
Okay.
monitor?
So, yeah, I can assign it afterwards
Okay,
if you
so
want.
it's 6725E.
No,
21E.
6721E.
Okay.
Okay. Any public comment? Seeing no public for comment, please
There's
call the
still
roll.
public here.
Aye.
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 Member Martin?
Aye.
Member Martin, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair Wolf?
Aye.
The motion passes.
Okay, and so we'll refer this, which committee?
I guess compliance and
Okay.
amendments,
Yeah,
but we should set some type of criteria for the rolling. Otherwise, this can continue forever.
Okay. So
there's 70,000 emails. I have no idea what
Right.
they can do on a weekly basis, but
I'm not sure how much you caught walking back in, but I think an initial maybe 1 week period where Mr. Smith prioritizes either by keyword search or by employees that they provide what your preference is, and then after that, maybe 10,000 emails per week on a rolling basis until everything's received. And if you have any, comebacks with your ID department, please refer those questions back to Mr. Smith and through us to our clerk. That was just one.
I mean, I think that the first few weeks, 10,000 is a reasonable number. Once we get to the ones that actually need to be read, getting a lawyer to read through 10,000 emails in a week is a joke. So that point needs to get pushed to a number that is actually manageable for someone to read in a week.
We don't know what that number is. That's the problem. But
Yeah.
We may, as Melissa said, we need to check with our IT department. I'm not sure that we won't need time to hire temporary staff to do this. They are already working overtime just to do our operations.
however that happens, some information has to be provided by the people you have on staff now. Now, if you can give and I don't know if you can give Mr. Smith, as you said, the type of employee. If you have janitors, he may not want janitors. If you have guards, he may not want guards. But if you can eliminate some of them, but regardless, information has to start going.
Understood. I'm concerned about committing to 10,000 emails in a week. But
Okay.
we will work on.
How many can you read in a week? Seriously, to go through them.
Anthony, what's realistic for you?
Let's not drive
I'm
this
finishing
down
a
too far.
book.
Yeah.
So this is going to be a task on top of a task. I'm in the final revisions of the book. I don't want to be unreasonable. I want to be reasonable. My anxiety and impatience is fueled by the fact I've had nothing over the course of a year, and I've managed to close the exhibition about Saudi Arabia, about Islam fashions. So honestly, whatever you think is reasonable, I would certainly accept. Honestly, but I don't want to be in a circumstance where I'm arguing with them because they say I haven't provided essentially search terms or specific names. Let them go by my request, which is the way this is supposed to work, and let them give me those things responsive to the request, please. And you set the terms. I'll go with what you say.
Okay. Thank you. Member Joshua.
I think that 10% of the 70,000 is a legitimate starting point, and that whether it's EOTC or compliance and amendments or one of our other committees, that by the next possible time we can schedule this, that he should have at least 10% of the emails, and they should have a plan for how they plan to deliver the rest of them with deadlines, and then we can approve that or disapprove that, as opposed to all sides saying someone set a schedule and nobody knows, and it feels like a shell game.
That sounds reasonable to me. Yeah. So that whatever committee gets it by that next committee meeting, at least 10%.
10% and a written plan for that committee to sign off on of how we're going to get to the finish line.
So to be clear, 10% is 7,000 emails.
Yes.
Right.
Okay.
Yes. I noticed that.
And the next committee meeting is, compliance and amendments. It seems like this belongs.
It really is more compliance and amendments.
Yeah. It's in April, right?
Yeah.
April.
Can we agree I'm not giving names or search terms or something? They're going off my requests, which are quite specific.
Yes. That's April 14th, so it's more than a month.
Are we the second Tuesday or the third Tuesday? Let me check.
So by the third Tuesday in April, Mr. Smith should have received 7,000 emails, and the Art Museum should have a plan on how they're going to provide the rest of them in over what reasonable time frame.
Okay. And I just, because I'm kind of got lost in how we're going forward, are we providing Mr. Smith the titles of the city employees, and he's telling us who, or we're just going through so he's not, because he seemed to go back to, I just want my request, which was, like I said, the co-fam to FAMSF. Right. So, okay, so we'll just start peckering down and the next, and the date for 7,000 emails is what?
April 16th.
April 16th. But not only the emails, but a plan on how you're going to provide the rest of them.
Can we know what the rate will be continuous of 10%? 'Cause I think that
you come up with a plan.
You come up with a plan.
And if you're going to hire people, I mean, this should not take another 6 months.
Gotcha.
May I recommend that if it turns out to be easy and you can get more done early? Yeah.
Right.
Yeah.
Minimally 10%.
Yeah.
Should we set maybe 3 months as a...
Let's let them come up with a plan and see what happens.
Yeah. Yeah.
Okay.
Okay. So the communication will be through compliance and amendments?
Yep.
Okay. Great.
Got it.
Okay.
Just so we're clear, I'm going to try to get some journalism students to help me and that sort of thing, not just me.
Okay. Very good.
All right.
Okay. Thank you all. Appreciate it. Okay. So this will be referred to compliance and amendments. All communications from both parties will now go through the Compliance and Amendments Committee, and then we'll expect that probably at the May meeting we'll get a report back, right?
You'll have
correct.
A plan.
Yeah.
Okay.
You'll have a plan at least by then.
Okay. Great.
And
Okay. Thank you very much. Let's move on to the next
Just one
item.
more question for those folks like me who don't understand the numbers, the ordinance numbers and so on. What violation was found? You just said numbers, so I don't understand. So you said
6721
Right.
E.
Which is timeliness?
So
It's about a paragraph long. I can read it if you
it's
like.
pretty
No,
long.
no, don't. I can look it up, but basically it's a finding.
It's if a custodian refuses, fails to comply, or incompletely complies with the request described in B above, which was the 10-day rule above, or if a petition is denied or not acted upon by a supervisor of public records, the person making the request may petition the Sunshine Task Force for determination whether the records requested is public.
So in my lay language here, it's a finding that they violated the Sunshine Ordinance.
Yes.
Th-
It's on the
Thank you.
record.
Okay. Next item, please.
Round 2.
Next item, item number 8, file number 18083, complaint filed by Mr. Smith against the Fine Arts Museums in San Francisco for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner.
I just want this single document. Yes, just this one page, please, if it's possible.
Up. There we go.
I can just move it, yeah. All right, so I just got this, and you recall that I was pressing to get documents about whether any funding had been received from Saudi Arabia or Saudi entities with regard, from, in general, stating it as broadly as possible. But of course, the reason I was prompted to do so was there was an exhibition put on Muslim fashions, and I was put on to it by a piece in the New York Times by a former colleague pointing out that this was happening. So I just wanted to know, did the museum get such funding? And I asked them, and they didn't answer. They wouldn't answer. So then I said, and I filed Freedom PRR. And I just want to show you, well, first off, what I got was little and didn't assist. But this came in 2 days ago, and I just want to show you what I've been faced with here, please. This is obviously a memo, and a board member says something, and the response is, "It's wonderful to receive greetings from," and they blacked out the country or city. Now, why did they do that? What's the basis? How could they redact that? And then you go on, okay, and there's a little bit more. Greetings from blacked out. Are we talking about Riyadh? What are we talking about? I don't know. And then it occurs once more, and here's where suspicion begins to rise. They didn't redact how best to handle, because it may be trying to block me given I'm logging in from. So she's obviously in a totalitarian or autocratic country. Which one? Who knows? It should never have been redacted. I give you this only because, doesn't it whet your appetite? It sure whets mine. I should have it intact, but I don't. And no legal notions of redaction, I assure you, or in my mind, have been met. What could they be? What could the basis be for redacting the name of a country? That's not personal information. In any event, look, I haven't gotten the documents, and they've managed to fob me off long enough so that exhibition has closed. It's late, and I appreciate your kind attention throughout. I'll stop.
Thank you. Are there any persons or witnesses provide any facts or evidence on behalf of the petitioner or the complainant? Seeing none, respondent.
I'm not even sure how that was relevant. So, and we cited that somebody's personal travel is protected as a personal information where they were during that time of year, and they traveled, and that's their personal travel. It has nothing to do with the conduct of the public's business. So again, he received those like previously in September. So I'm not really sure how that's relevant. So I'm just going to go to the case at hand, which goes to, I think, very much to the point of what was raised in the previous case, was the fact that Mr. Smith has received the city records. He received the emails that the director was on, and he also, they are outlined for you in the record. And the issue in terms of any other emails that he believes that are there are of COFAM employees. And we've already maintained that a COFAM, if it's in Silo 2, then it's not subject to the California, to records release. So it's a very closely related issue, and that's pretty much what our position is. Our position on this is that we have given him the responsive records.
Okay, are any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members? Member Joshua.
I have a question for the museum.
Ms. Powers.
Ms. Powers, I mean, either representative, actually, but I understand how where this person went on vacation might be private information and perhaps shouldn't have been discussed via email in the first place. But what is the actual reason under our law that you're utilizing that particular?
Trying to find where my notes were. I'm not sure what happened. Oh, they're back there. It's the section.
Microphone, please.
Section 67.1, I believe, that deals with the privacy of individuals. I don't have my notes in front of me regarding the specific site under the ordinance, as well as just even under the California Constitution, that people's privacy. So we gave them the email that of what was the request, but again, this is not germane to this complaint.
It doesn't really matter whether it's germane, because basically we have a situation where we have redactions happening. We don't know what's in those redactions. The government very clearly defines out what those redactions were. If that email that had been raised said, "Don't tell my wife I'm in Libya," like, you could be like, well, we're holding this information because clearly he doesn't want his wife to know, but he shouldn't have said it in the email. Like, the fact of the matter is that, yes, people say things that they don't want revealed in emails because they're not thinking about the fact that they're public emails, but that doesn't serve as a reason to redact information.
Let me just interject. I mean, Smith versus San Jose allows for redactions.
Well, I'm not saying it doesn't allow for redactions. I asked her what the reason for that specific redaction was.
Right, and it was.
Okay.
My reason was.
She said.
Here it is.
She said it was related to personal travel.
Correct.
That's
Thank
not
you.
Is
related.
that one of the listed? My computer's been dead, so I can't Google anything.
So, in correct me if I'm wrong, DCA Price Wolf, but under Smith versus San Jose, you can request information off of personal devices with regards, but it has to be parsed out as to what's business and what's not personal.
But this isn't a personal device. This is a work email between two work.
Online accounts, email accounts. It's all part of the same rubric.
Right, and this is an outside person.
And I'm sorry, and so the opportunity is for the personal messages can be parsed out. They can actually be withheld versus the messages that are pertinent to the request.
If she had said, I'm where I am because I'm getting, this is a hypothetical, I'm getting treatment for an illness, I would redact that due to personal privacy rights.
It's the there are actually in a lot of guides and tutorials around Smith versus San Jose, they give those examples. What happens if there's a mixture? What happens in the first paragraph? Hello from Florida, I'm having a great time. Now, on the issue that you're talking about with regards to this document that I have, you can redact the first line because it has nothing to do with the actual business at hand. And you can request the information, that email or that message from their personal email account. if that's where it was sent, if it was found that that's where it was sent.
Right, but in this case, we're not dealing with personal email accounts.
That is from
No, but you're dealing with it doesn't matter where it comes from. It's either from a city government public email or from their personal devices or accounts. That's the way, as I've been trained and have read through Smith versus San Jose, that's the way it works. So, yeah, member testifying.
How do we know that this is for private travel? That's a large concern of mine. I know from my own practice of needing to produce Public Records Act documents, there has been very sensitive information about travel that public officials took that could have been alleged as personal travel, but it was actually not personal travel. And it required looking at the whole document to see. And, once people saw where the travel was to and were able to identify other people that were at that same location, it was found that it was work-related and that collusion was happening in Poland. So that's why I'm concerned when I'm reading this. Granted, Mr. Smith did give some flourishes, like why would the email be restricted unless it was in a totalitarian state? That might be reading into it too much, but I think that we cannot go by the word of the respondent that this was definitely for personal travel, the location.
And when I'm reviewing these emails, I have to go with an email that I didn't, I'm not there. So I have to use my judgment in looking at the code. So your point is very well taken, but this was the trustee. This wasn't like a worker from the museum that I could go walk down the hall and say, hey, were you there for work? So when I'm reviewing and when I'm going to be reviewing 70,000 emails, I can't go on a fact-finding query to know why a certain line is in there. You have to, at a certain point, make a judgment call and apply certain redactions.
It's tricky.
I'm concerned. It is, but here's where this is the discovery part, right? And so where redactions or withholding of information happen, the respondent has to give as Member Josh Wolf was asking, just a reason. Okay, the reason was given. Okay, but we always run into this kind of legal firewall where we can't see things in camera to make a determination of it. So if there is some belief that there's something more to it, as what happened in your situation, I mean, we don't have an administrative law judge that can actually see things in camera, that's legal in that kind of way, or we don't have the privilege of a kind of a behind closed doors discovery investigative unit like the Ethics Commission has, where they have the authority to do such things too. So that's where we're limited in that way, and that's why we always ask for a citation as to why it is. Now, if they're going to cite Smith versus San Jose, there are some standards, I think. I can't tell you what they are. That's a little more down the legal road that I'm qualified to answer, but I think that's the crux that I can give at this point. We've run into this wall before, where there's a certain amount of limitation that we have. And we can only compel if the information is public to produce the documents, redacted or unredacted. Documents have been produced. There's the question of compelling for more information. They've given a reason. I take it from there. If you want to dig deeper, go for it. I'm not offering an opinion otherwise. Just that's the explanation. Did I kind of get that right? Or something to add?
The San Jose case, my take on it, I don't have it in front of me either, was that it really grappling with what is a public record and essentially can you quote unquote hide public records by putting them on personal devices? And the answer to that is no, right? So you can, if a public official has their own iPhone and they're doing work on it, those are public records. That's what that case was really grappling with. This is a little bit different, but I think a lot of the same principles, you can have guidance from that. I just wanted to add that.
Thank you. No, we're having a discussion between us here. Somebody have any further questions? If not, should we move to rebuttals? I mean, what do you think? Yes?
What are rebuttals?
Okay. So, Ms. Powers, you have 3 minutes for rebuttal.
Okay.
We're going to move to, so our process is, we
Okay, so I'm
opening
going to
statements, have some discussion.
Okay.
You can offer rebuttal, and
All right,
Mr.
so-
Smith will have rebuttal, and we'll decide.
Okay,
what to
so
do.
I'm going to move back to the issue of what's in the complaint. The issue, because he had that with that redaction since I think like October, but that's beside the issue. As we've stated, we have given him the city records. We outlined in our response when we first went to the complaint committee, which is your attachment 1, what records we provided, and we listed all the relevant records. He is reading those emails and he sees, and he knows that one of our curators, who is a COFAM employee, or one of the COFAM employees, was involved with the exhibit. But once we start dealing with COFAM communications with a third party that is not a city employee, we deem that as not subject to the Public Records Act and not one of our city records to release to him. And we gave him a list of the records that we deemed that were responsive. And it does circle back to the original, whether he's saying he gets everything that's in Silo 2 or Silo 3, but we reviewed the request. We gave him what was in Silo 1, meaning all responsive city records, and we satisfied his request.
Okay, thank you. Mr. Smith, you have 3 minutes.
Historical footnote. Many years ago, I appeared in this room on behalf of KQED trying to get them to let us televise the trial. We lost. I'm going to give you another request, just saying I want to see the documents relating to the funding in general of the Saudi exhibition, of the, Islamic fashion exhibition. I heard something that should perhaps give us pause. I heard again that Silo 2 is not producible. I thought we had decided that Silo 2 is indeed producible. And it's not just emails about Saudi. May I say, to cut through all of this, in my perhaps not objective view, a lot of this depends on who's doing the screening of the documents and his or her training. The bias has to be in favor of giving the public the information. That's got to be the bias, not the institution. But beyond that, you've been kind enough to say that you haven't had training in dealing with public records requests, and maybe I respectfully suggest it wouldn't be
All right, we're not going to have this back and forth, Mr. Smith.
Right,
Your
okay.
attention is on me, not on anybody else. Thank you.
Yes, thank you. They have 2 lawyers. They have a law firm, and they have the city attorney's office, and they have a lawyer in each, so they've got plenty of know-how about this. But when they screen these documents, I would respectfully ask that they go by the law at the very least. It's not intuitive. Whatever one thinks. And for example, about the document I put up there, that's a business document. It's from a director, wherever in the world she was, to the museum on the subject of whether she had to report certain financial matters to the city and county, given the fact she was on leave of absence at the time. It was wholly a business document. But that's just a concrete example. All I want is to see the materials, please. Thank you.
Thank you. No. Well, that's why we do these rebuttals in this way, but we're not going to have a debate back and forth.
Petitioner gets the last word.
Yes, that's how our process works. I just want to. Yes,
go ahead.
I just wanted to make sure that we are clear on what the request that Mr. Smith has made for this particular case. And I just want to be clear because I think I'm hearing more than more information is being requested than what has been. More information is being asked for than what has been originally requested. And I just want to make sure that I'm clear on it. I want to make sure everybody else is clear. So I'm reading on page 1194, and this is the original request, I believe. It looks like it of October 14th, 2018, and it's one item, and it says all documents related in any fashion to subsidies, gifts, travel, hotel charges and payments, meals payments, expense reimbursements, contributions, endowments, money, and or anything of value given, lent, or supplied in any fashion by the King Abdulaziz Center of the World Culture or any other Saudi entity, public or private, from January 1st, 2016 to the present. That's the scope of this particular, okay? I just want to make sure with the parties, are we in agreement that that's what we're working on here and nothing more outside of that? We are. Ms. Powers? Ms. Bourne? Okay, thank you. Okay. All right. How should we dispense with this?
Did we ask Mr. Smith if he received all those documents, even though they might be redacted?
I don't know. There was a lot of focus on that one document around redaction.
Not part of this.
They were the request. Where is it here?
Respondent claims they did send all the.
I just wait a minute. Hold on.
Okay, you don't have to.
I am trying to figure out if there are any limits to my scope, to the scope here. Okay, you want to ask that question? Go for it.
Sure. Mr. Smith, please approach.
It's a clarifying question.
Just a clarifying question. Given that we've just restated the scope, have you received what you believe are responsive documents to that original
I'm
request?
confused. I didn't know I had restated the scope. I said that in an effort to clear this up, I would simply send another request that says essentially that, but give me everything relating to the funding of this exhibition, which presumably would sweep in anything from the Saudis. I was trying to make it easier, and I apparently failed.
Okay.
But I didn't mean to say that that was the scope of that. It's not. It's related to the
All right.
Saudis.
What have you received anything from them on this?
Very little, and nothing that relates in any fashion to funding. There was something about, I don't have it in hand, but I remember it, the director was invited to a cocktail party given by a Saudi here, and some other people were, and some turned it down, and some didn't, and it didn't add up to a hill of beans.
Okay, but your original request was subsidies, gifts, travel, hotel, et cetera, et cetera, et cetera. So you've received very little in response to that?
Yes, and they sent me an email. I'm sorry, I should have my iPad or something, saying that I said the sequence was I asked for the information. The museum didn't even respond. Then I sent the public records request, thinking they'd be compelled to. Then I sent. They said they didn't have anything more or less, or they had some very few things. And I said, listen, please be careful, because I would not like to see you change this down the road. Do you understand there is in the public domain material on this subject? If one searches the web, one finds that your personnel were in Saudi Arabia or some such thing. And after that, I got documents. But I also got an objection, essentially, that they were employees, not of the museum, but of COFAM. Right. And therefore, it wasn't susceptible. The records weren't susceptible to production, and they were personal records or some such thing, even though, of course, they weren't.
Okay, thank you.
Member Josh Wolf.
I hate to keep bringing up these weird things, but if the Sunshine Act talks about what documents a government body is in possession of, it sounds like even though they're not their documents, FAM is in possession of COFAM's documents because they're on the same server that they both have control over. So I don't know whether there's any legal way that one navigates that, but that's the way I read the Sunshine Ordinance, and I'm a
little confused. You're saying that just because documents exist on a server, that one entity is not able to access?
No, I'm saying that because they are able to access it. Like, we have basically heard testimony, I believe, to the extent that COFAM's email is accessible to FAM's tech person. They're in the possession of... They share possession.
It's a COFAM tech person. It's a COFAM tech person.
Ms. Powers, we'll ask you to speak if we need. Thank you.
Well, that only muddies this further.
Let's be clear on these are. If we're talking about them as silos, then let's talk about them as silos. One silo, even though it's on the same server, you know how servers can get divvied up.
Well, I mean, yeah, Amazon has all kinds of stuff. Like, we're all on Amazon servers.
Yeah, but it doesn't mean that one silo gets to see what the other silo has.
Oh, exactly. I fully agree with that, but I don't think that we're not hearing them discussed as silos, actually. Like, we're calling them silos.
But you're stating just because it's on one server that everybody broadly has access to all documents.
Well, no, I'm saying that the person who is sifting through the access of the FAM records has access to the COFAM records.
But that's not the person who's the custodian. That's just the person who's providing the mechanics for getting access. That's to me, that's a little far-reaching.
If that person isn't the custodian but is acting on behalf of the custodian, I can see that argument.
Right. Because look at who the petitioner is asking. This custodian. Okay. This custodian can then ask their tech person, "I need this information. Can you go and get it in this kind of whoop-de-doo, ziddly-dat tech kind of way that I have no knowledge of doing?" Okay, they're just given an order. That tech person is not the custodian. They don't. If you ask if Mr. Smith asked that tech person for this information, he would say, "I don't have it." You're going to have to go talk to Ms. Powers. She's the one that controls that information, not me.
Well, Ms. Powers, I hear the front end of your argument, and
okay. So yeah, let's just deal. There's no cross sections in this. I think what we need to just determine. The question is whether Mr. Smith had gotten all the information he wanted. Ms. Powers, I'll give you an opportunity to respond to that.
Thank you.
But before that, I was just going to say, haven't we established in the previous case the fact that these are all?
No, this is a different request.
But they're still citing the same defense. Oh no, those are actually COFAM.
So what?
But we've already worked through that
It does.
we felt those were public
So
records?
then you can make the same motion.
Okay.
You know, I mean, it's they can keep repeating the same defense over and over again. It doesn't matter. It questions is how it gets applied to the particulars of the case. So
I mean, if they're saying there are more documents that are responsive, but they're
I know,
COFAM
but
documents.
focus on this case. It has nothing to do with previous or other cases. It focuses on what he's asking for in this case.
But he said that they said there were more Saudi documents, but they're COFAM employees' documents, therefore they're not releasable. That's what he just said. And
Okay, fine. Let's
explore that.
Ms. Powers has a response to that, so
Right.
let's hear
So,
what she has to
in
say.
terms of his requests, which would be consistent with what you're now saying you're going to request tomorrow, which would be interesting because we're also going to be working on your other 70,000 emails, is the city did not receive money, and that is why he didn't get. That is why there's only 9 emails to give him. We gave him the responsive records. That's. And that's why, when we got the criteria from the city attorney, but not the legal final answer, this will go around and around. Like he doesn't think we gave him responsive records. We do. We gave him the records that the city employees were involved in regarding this request. And and even if he were to reword it, give me the money, give me the emails that have to do with this funding.
Okay.
It's COFAM versus the Silo 1, Silo 2, Silo 3, and we gave him what was the city's involvement with this request.
Okay, thank you. I mean, this is not unlike some of the other cases that we have to deal with. When a department says we've given them all the quest, the only question we can ask at that point from the petitioner is, are you aware of any other documents? So, Mr. Smith, are you aware of any other documents other than the ones that they provided you that could or would be responsive that they may be withholding as either not being public or that they may be unaware of?
I need some help here. I thought it had been decided that the information on the shared server, the Silo 1, 2, 3 business was my nomenclature.
Okay.
Are you saying, I thought I had heard the reverse. What I just heard from the museum was that there may well have been money from Saudi Arabia or elsewhere funding the exhibition, but because the money was handled by the entity called COFAM or the entity called FAMF and not the whatever one, the city, the one called
FAMSF.
Whatever.
Fine Arts
not.
Museums.
I'm not going to get it. They're able to shield it because there's another entity. Even I won't go over the arguments again. But is that possible?
Yes, it is, because that's been the crux of our all the cases that we've been working on with you around this is the legal entity of those two nonprofit corporations as to whether they are responsible custodians and to provide documents or not.
I thought you had a legal opinion and statutory and case authority, decisional authority that said that they must be responsive. I thought this was decided.
Well, my question before was whether this is a 12L or not, because they're nonprofit organizations as to whether, but under 12L, even though they have a memorandum of understanding, they would have to be receiving money from the city, and they stated that COFAM and the foundation, which are independent nonprofits, do not receive any money from the city.
When you go in the museum, let's be realistic for a moment. You go in the museum, you pay for a ticket, you join the museum.
But that's the city, that's the Fine Arts Museums of San Francisco. That's the city agency.
And that is where they're getting their money.
Right. So the information that you're requesting is from the city's Fine Arts Museums. That's where you're at. That's
but if COFAM or whatever is getting is in fact collecting this stuff, which was the purport of the first letter I put on the screen. That woman was asking, "You're getting all this money. Where's the agreement? Well, where's the accounting?"
Who's getting money? The city
No,
museum?
COFAM.
COFAM's getting all this money from the museums?
From the admissions to the exhibitions and the special exhibitions. That was the thrust of the first letter. So it defies, in my mind, common sense that if COFAM is getting all the money when somebody lines up and pays to get in, that I shouldn't be able to see the records.
All right, so this brings us full circle again. So please have a seat, Ms. Powers or Ms. Bourne. Let me ask a question based upon what Mr. Smith just brought up. Is this correct that one of those organizations receives their funding from the admissions from the Fine Arts Museums of San Francisco?
COFAM does not receive any funding from the city and county of San Francisco. We could furnish the city budget. The way the city supports the Fine Arts Museums is by making direct payments to city personnel. So that all goes through city payroll, and making direct payments to contractors to take care of capital projects at the museums. And the city, so, repairing the columns at the Legion of Honor and, leaks and things like that. And the third way that the city supports the museum is by making direct payment for our utilities, the light bill, the water bill. They pay for the city attorney services that we receive directly. So there is no money that transfers from the city and county of San Francisco to COFAM.
So Mr. Smith is incorrect? He's basically saying
I wasn't sure I understood what he was saying.
He said that COFAM is receiving money through the admissions of the tickets that are purchased at the museum for entry into the museum.
That is correct. So because all that is the earned revenue that comes into COFAM in part to operate the museums. We do have an interesting interchange with the city on that front because we're required to have city-paid admission attendants. However, the city, they are paid through city payroll, but COFAM is actually required to take the money out of the admission revenue, send that to the city to pay for those employees. So COFAM is in fact funding those positions, but they're paid through city payroll. But that's the one weird.
So but you see, I don't know if I can make it. Just let me ask one more question. I'm just trying to get it down as close to the crux as possible. If the city has a memorandum of understanding, a contract, an agreement for an outside entity, a third party, to provide services to one of its facilities, and it either gets paid in some way as operating that public venue or attraction or what have you, whether that money comes in the form of a check from the city or it comes through admissions that it collects itself on behalf of the city, it's still the same thing. It's still receiving money from the city. It's city's money. And that's what the purpose of the memorandum of understanding is.
I'm not sure that I see that as the purpose of the memorandum of
What's
understanding.
the purpose? What do you think the purpose of the MOU is?
It establishes that the Corporation of the Fine Arts Museums and the Fine Arts Museums Foundation provide substantive support to the Fine Arts Museums of San Francisco to handle the daily operations of the museums and to right. So, but that's actually the city entity is receiving support from these others. It's not that COFAM is not receiving support from the city.
Yeah, I understand. So let me give you I'll take it into a different analogy. City Carto.
Mm-hmm.
Okay, it's an independent agency. It's a for-profit organization, a for-profit company. Okay, they operate. They do all this work around the city. Towing people's cars. You go into their office, and you pay. Okay, and you get your car back or whatever. Okay. All that is still public. They're under the same scrutiny because they have a specific MOU or contract with the city. Even though they're collecting the money from the public, there's a contractual agreement, and so whether they get the money maybe the money comes in, it goes into the city coffers. It's got to be reported through the controller's office or whatever the city's finance process is. And then a check gets released to a city carto, or there may be some other arrangement. Either way, they're still working under the auspices and on behalf of the public agency of the government. So it would seem to me it's somewhat the same rubric.
Mayor Wolf.
Yeah.
Ms. Powers, on that same note, you said that the COFAM collects admissions, sends that to the city. A portion of that is used for payroll back to COFAM contractors. Right.
No, not contractors. No, it's paid. It's not paid to COFAM contractors. It's to pay 3302 admission attendants. Those are employees of the city and county of San Francisco.
Okay. Now, does COFAM also send monies that it receives towards exhibitions to the city? A percentage?
No.
That it keeps directly for itself.
Well, it keeps it in order to pay what it costs to put on the exhibitions.
Okay.
I want to make a suggestion in the essence of time, and I think it's kind of like it's kind of going into an area that I feel uncomfortable with for this particular body to delve into deeper. I would prefer to get an actual determination either from the city administrator or from some other entity that manages these relationships to determine exactly, to help us know what it is. We have been going round and round in a lot of ways. The question is are documents that should be available to the public be available? Is the respondent's response is because they should not be available to the public because they are not part of the city government, they are private entities. We still don't know what the relationship is. So, Member Josh Wolf.
So if I understand this correctly, and Mr. Smith, if you can approach the mic just to verify that this is my correct interpretation of what you're saying. You're saying that it is possible, on your suspicion of possibility, that the government of Saudi Arabia is giving money to a private nonprofit that's associated with a government, our city government, of a museum, in order to do whatever the Saudi Arabia government wants to do with spending money for a museum. And that money goes to this nonprofit that then solicits the public to pay money to go to this public museum that then goes into this cycle. So, and that if there is money coming from Saudi Arabia to this nonprofit that's directly tied to a city museum, that we would have no way of knowing. Is that essentially your...
Mainly correct, yes. And so you won't I retain the cynicism or paranoia of a reporter. The lead donor, the most important, the biggest donor to that exhibition listed by the museum is anonymous.
Great, thank you. I don't know how to parse this, and I'm inclined to follow Chair Wolf's lead here, but when it comes to the fact that we're dealing with a potential situation of a foreign government funneling money into a nonprofit that then enters sort of the city's financial realm, this is really sort of, it has that ooey, what, I don't, beyond my legal apparatus pay level, and I'm concerned. What's especially concerning is that we can't get an answer. No, Saudi Arabia didn't give money to this private nonprofit that is directly in bed with the city's own museum.
Mr. Wolf, you should also know, fact two, that a curator or curators of the museum went to Saudi Arabia. I tried to find out at whose expense, and they didn't tell me.
With the chair.
Member Canada.
I agree, Member Wolf, and I'm even more concerned because we've had two other cases that were mentioned before with the Friends of the Public Library and with the Bayview Opera House. It seems to me that government agencies that are obligated to follow the Sunshine Ordinance, if they contract with an external entity, whether it's a 401c3 or not, they can hide information like this, or they think they can hide information like this. And this is why the case we had with the Friends, where it's yet to be determined that the Friends should follow all of the Sunshine Ordinance and not just the one section where it says they have to list all the donors.
Right. This one bothers me more because there's the potentiality of foreign governments involved.
Foreign government can give money to the Friends.
I mean, they could, but we don't have any accusations of that.
Right. But to me, it's the same issue where city departments seem to be setting up structures where the public can't get information.
Mr. Kanata, may I just say, and then I'll stop with your kind indulgence, it could be worse than this. It could be that what's happening in this city and country is that an entity like a museum is deliberately setting up on its own another entity, giving it a legal label, not for profit, whatever, and claiming that that other entity, to which it turns over all of the financial aspects, all of the employment aspects, virtually all of it, including the exhibits, and when you go in and pay, it's going to that entity, is entirely shielded from public media scrutiny. Can't tell. Did they make money, lose money, who paid, who subsidized, who did what? That's why what you're doing here, and I thank you for your patience and care, is so very important. Not just to the media, but to everybody. Do you want to live in a city when the museum is a hidden entity? I don't.
Okay, I'm gonna propose a motion. Motion is to continue this item and to request from the city administrator the explanation of the contractual relationship between COFAM, a third party, FAMF, a third party, and FAMSF, a city agency, so that the Sunshine Ordinance Task Force can determine if the third parties are subject to the Sunshine Ordinance. Motion is to continue the item and to request from the city administrator the explanation of the contractual relationship between the Corporation of the Fine Arts Museums, which is a third party, the Fine Arts Museums Foundation, which is the third party, and Fine Arts Museums of San Francisco, which is a city agency or department or entity, so that the Sunshine Ordinance Task Force can determine if the third parties are subject to the Sunshine Ordinance.
I'll second that.
Any discussion on the motion? Any public comment on the motion? Okay, call the roll.
Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
The motion passes.
Thank you. And
Aye.
thank you for
Canada. You didn't call
Member
me.
Canada.
You didn't call me. Aye.
I'm sorry.
Hey,
Jesus,
this
how
doesn't
am I
affect
forgetting?
the other case, right? You're finding their stance.
Case number 18083. I think that's what this one is, right?
Yeah.
Only, so the other one is.
They're two separate cases.
Right. The other one's done, and whatever you did stands, and here you're seeking clarification from these folks.
Mm-hmm.
Thanks.
Okay. Let's call the next. Thank you, everybody, and thank you for your indulgence. Okay. Let's call the next item.
Item number 9. As I said to the committee before you came in, I heard from the Parks and Recs Department last Wednesday. Tiffany Lynn Wilson, their custodian of records, called or emailed me and said that Mr. Cornell, who I'd known previously was going to be unavailable, his supervisor, Dennis Kerr, was also unavailable. He was going to speak, and when she found out, she got in touch with me immediately. So,
When did this call come?
last Wednesday, about a week ago.
Oh, okay. This is after but this is before the agenda went out.
Everything in the agenda was ready to go. I posted it on Thursday because I knew I was going to be out part of the day on Friday.
Oh. Okay. Is Mr. Clip here? Josh Clip?
I think you informed him as well, right?
I
Oh, you
informed
did?
Mr. Clip what
And what did he
happened,
say?
And he was fine with it.
Oh,
He said if it has to be continued, he was fine with it.
okay. All right. So is there a motion to continue this item?
So moved.
Second.
So moved by Member Hinsey, second by Member Josh Wolf. Any public comment on the continuance? Seeing none, can we take it by acclamation? Is there any objections? Seeing no objections, the motion passes. Okay, let's move to the next item.
Item number 10, file number 19013, hearing to review the San Francisco Police Commission's response and actions on February 20th, 2019 to the Task Force Order of Determination regarding file number 17131, Magic Altman against the Police Commission.
Yeah, so I put this on the agenda because this was kind of an interesting set of conditions that happened at the Police Commission.
Are you guys all able to see the video that I attached?
Shall we show it? How long was that video? Wasn't that long, was it?
Are we at a 9:30
Full
stop
video was
because
like
of
45 minutes. I couldn't cut it.
the recording? Through the chair?
Sorry?
Do we have to stop at 9:30 because they stopped recording? Is that the normal cutoff or no? Okay.
No, it's usually the time they want to kick us out. Where is the
Attach the link to the cover page.
to the cover page?
I remember reading about it. I don't remember a video.
Where is? I don't see it on the. You mean on the PDF cover page, like the first page of the agenda? Oh, the first page of the item. I got it. Here it is. Okay.
Item number 10.
Yeah, it works. I think.
I couldn't
Yes.
cut the video to show only that specific
Oh,
hearing.
okay.
Okay.
About that.
Okay. This was the number 5. So
Can you go to the link and click on the?
yeah, I got it. So it starts at 1:59, and general public comment starts at 2:45. So that's a 45-minute clip.
Through the chair?
Yes.
Was Magic informed that we were planning on discussing this?
I don't think so.
I thought I saw her in here when I walked in.
Oh,
No?
I don't know.
Not today?
Yeah, not today.
I don't know, but it was more, if she wanted to be here, it's fine. Was no
There's no need for her to be here. I was just asking if she was notified that we were.
I didn't contact her.
No, we didn't. I didn't make any request to contact her. I don't recall I'd have to watch the video again, but it was a little disturbing at how they dismissed our determination. And so I wanted to bring that up because, is this something that we want, how should we deal with such things? Is there something that folks want to do? Make an inquiry, send a letter,
Refer the commission itself to ethics.
I mean, are they actually, the question becomes, will they still be in violation if they if they do this again? That kind of thing. I wanted just everybody to be very aware of, here we have, a level of, I don't know if defiance is a correct word, but definitely disagreement on it. So if you haven't seen the video, I'm happy to continue this to the next meeting, but everybody please, I review it, and if you, and we can discuss it at the next meeting, and do you want to do that? Okay, yeah. People are unprepared. Okay. Mm-hmm. Yeah, Joshua.
I don't think Magic should feel obligated to come, but I think that it makes sense to notify her that this is on the agenda.
We have no obligation to do that. Why?
I agree we have no obligation to do it, but it's the issue that she put forward, and I think...
She was there.
No, I know she was there. I'm just saying that sending her an email that it's on the agenda makes sense to me.
Why should we make a special circumstance for a particular person? I'm bringing this up as a general interest issue for a city commission who is, after the case is over.
Also, he can notify her if he wants.
Yeah, you can do it on your own, but I think it's inappropriate for we're notifying the public in general already. I don't think it's appropriate.
I mean, the parallel is when we had some cases that pertained to the Library Commission but was no longer part of Ray Hartz's item, we still notified him.
I have no knowledge of that.
We're not planning to hear from her or anyone else, are we?
No.
This is just closed kind of discussion.
I mean, there was the same, Hartz was not a party to the item, but that's fine. It doesn't.
Yeah, I'm not.
There's bigger issues to worry about right now.
Yeah, I'm not aware that any special accommodation was made for general interest issues that we want to cover was made to specific parties. I mean, you could do it privately through the grapevine.
Right. I mean, I don't see it as a general interest issue. I see it as the continuation of her claim that we found a ruling on that then was ignored by the party that we ruled against. But
if you want to order it, okay, I'm happy to consider it. I mean, you have just as much authority and jurisdiction as I do here with regards to something like that. If you want to procedurally have Ms. Altman contacted for that item and have our administrator do that, say so.
I think we should.
I think, or is it a request to do it?
I would like to make a request to do it. I feel weird that I'm ordering our clerk to do it against the wishes of my colleagues, though.
No, but
I think the clerk should explain that this is that she's not being asked to present or talk, but it's really
just to notify her this is happening.
Yeah, that's all. It's just a matter of process. That's all.
Right.
Okay. All right. So please, for next month. Thank you. Just be deliberate. Just asking you to be deliberate. About what
we'll send that notice with as a FYI and not as a notice to appear.
Right.
Yes, please. Thank you.
Okay. All right, and it's you should watch it. It's very interesting.
Still can't find it.
It's if you open up the actual item.
It's under other. You know how at the top you have like the check boxes, and then under other it says hearing to review, and then there's a URL like 3 lines down.
Yeah, it's on that cover page where it has all the lines and the check boxes.
And if you click on those, it's an active link.
Yeah. And it starts, you can just click on the agenda item where it talks about determination of sunshine ordinance. And, yeah, please watch it. I
kind of
think,
faded.
it really speaks directly to the work that we do and, that kind of thing. And this is not the first time that we've had these kinds of issues where it's actually on video. You could watch it and see and hear people talk about it right in front of you. So
Do we have the minute reference?
Minute? Yes, it's if you scroll down.
159, it was 159 to 245.
Discussion, right there. Discussion of Sunshine Task Force order.
Got it, number 5. Thank you.
Okay. All right. So can we continue this by acclamation?
Yeah.
Okay, it's no objection. Okay, great. So that will happen. The next item is item 11.
Item 11, file number 19010, consideration of actions to be taken regarding complaints pending before the Sunshine Task Force filed by Ann Trabeau against various city agencies due to inactivity and or non-responsiveness to communications.
Okay, so
If I could provide an update.
go for it.
In addition to phone calls, we did receive an email from Ms. Trabeau today at about 12 noon. She has stated that she has been in the hospital for the last month, out of state. She has also stated that her email address was hacked and therefore she was not getting our emails to her. And in addition to that, she did talk a little bit about court case filed by Ann Trickey and her failure to file a filing fee. I will distribute that email to all the parties, all the members via email.
And
However, sorry.
Go ahead.
This is not a first-time occurrence. However, we don't have any policies regarding this type of issue. So you may want to refer the question to the Rules Committee to develop a policy regarding this.
I believe you already have, actually. You sent me an email about it. Victor, just to clarify, this is from the account of Ann Trabeau?
Yes.
Using that name? All right, okay.
And a possible suggestion would be to continue this matter to the call of the chair and to not schedule any of the items until the issue can be resolved, and only if Ms. Trabeau agrees to appear on a specific day will we calendar these matters again.
Through the chair, and couldn't another option be to have these have all been scheduled before and she hasn't appeared? Is that correct?
A good many of them have. However, we
Continue to get requests under aliases.
this one is not the alias.
Yeah, this is not
No,
the
this is
alias.
not.
This is a different, this
Okay.
is,
So I guess we do need a.
I think we should handle those two differently.
We do need some we do need some procedures on how to handle it.
And then, besides that, just the pure volume of the complaints filed by one person, there's no way we can hear them all within the next 3 or 4 years.
Right, and this is, we created a policy of not hearing from the same the same person twice in a meeting.
More than twice.
More than twice in a meeting.
Right.
So, in order to allow a more diversity of cases to come through, so one person can't commandeer a meeting. I think we did have one special meeting where
We've done it more than once. We've done it at least twice. Once prior to your return to the board or to the task force, where we did meet and try to resolve the issues. However, it builds up after a time, and it comes to this point again.
Right. So I would say yes. So let's just leave it at the call of the chair. We don't really know what the dispensation is of this person or this, surname.
And I believe that you did send me an email requesting for it to be put on the Rules Committee agenda.
Yeah, I did.
Yeah.
And this is with regards to Impersonations.
Yeah, but I believe you only included a reference to aliases.
Yeah.
Okay.
Yep, more or less
Yeah.
the same thing.
Yeah.
We'll have more information on that at the April meeting.
We should- sorry. Please continue.
I'll mention. I'm just going to mention it. I'll mention it now. But we're arranging a meeting with the staff of the Arts Commission because there was a letter that a memorandum that came out from the city attorney's office with regards to Ms. Trabeau and other named people, and so it may shed a little light on how we might address these things in the future, based upon a more of a legal stance. Because we do have we do allow anonymous, so you can get the same anonymous 50 million times, right? You just don't know if it's the same person or not, right, per se. But we have to kind of figure it out. Okay.
And something else to add that is related would be the volume of complaints.
Right.
We have the anonymous, and then there's the pure number that we should address.
Right.
We've tried to tackle that in past years with was it vexatious or other terminology, and we backed away from that in the end.
Yeah, I think you're going to have to look at kind of the subject matter. What's being it's the requester, what they're asking for, based on specific subject or
and
focus,
the respondent, right?
And the respondent, and looking at all that together, two or more are duplicated, that kind of thing. And we kind of experienced that a little bit with two cases here today, in that kind of way. Were they so different that they couldn't be combined, in that kind of thing? That's one of the reasons why we created that rule around combining them too. So same person, almost the same request on the same subject matter on the same respondent gives us authority to combine them. So if you have 15, they all come down to one with just all those case numbers. You come up with one determination and one hearing, that kind of thing. So it really cuts the backlog down a lot. All right, well, onward to rules to figure it out.
Yep.
Okay. Anything else, Victor?
No.
On that?
Need a motion?
Vice Chair? No. If you want it, somebody wants to make a motion, we can just leave it as is to the call of the chair, because this is a matter of scheduling. And because we got a message that Ms. Trabeau was supposedly deceased, it was unclear what was going to happen with those. So now hearing this news,
right,
we'll just kind of leave things as is, and I'll schedule it as things need to be scheduled. Okay. Next item.
Next item number 12, reports from Sunshine Ordinance Task Force committees.
Okay. Complaints Committee, anything to report?
Well, I chaired my first complaints committee meeting.
Yay! You survived.
Member Highland did a very nice job of helping me along.
Okay.
So it was fine. It went well. So that dealt mainly with complaints regarding the library, and I think in Mr. Warfield. So.
And actually, we dealt with this last item 11 as well, somewhat.
Yeah, a little bit.
That was the first time we've actually heard one of the aliases up before us, so that's also with the Rules Commission, Rules Committee.
You heard from one of the...
Well, no, they didn't show up, but that was one of the cases where one of the aliases was before us.
So what?
Supposed alias.
Supposed
we
alias.
don't know if it's a real person or not.
So when she was called, they didn't show up.
There was no one. There was no plaintiff. There was no nobody here. So we.
John Cote was here.
Yeah.
Yes, he was.
No, I'm talking about on the petitioner's side. No one showed up.
I see. Okay. All right. Compliance amendments, anything to report?
No.
Okay. EOT, anything to report?
Nope.
Okay. Rules Committee?
We are having a meeting at the end of March before the complaint committee. I don't know if I need members for that meeting. I think I do.
We can check now.
Yeah.
I don't know who the members of the Rules Committee are at this time.
It was Lou and Highland.
Kate. Matt.
Oh, okay.
Matthew
Yeah.
Kate was the one who did it, I think, right?
Volunteer.
I'm doing rules. I'm also substituting for member Kate.
Oh, right. That's
I thought,
right. Yeah.
And anybody is welcome to attend. Just let us know you will attend so we don't have a quorum of the full task force.
Right.
And are we going to have rules followed by complaint? Are they back to back?
That's another issue we can talk about when we get to the scheduling.
Oh.
'Cause I've got complaint committee already on here on the 26th.
Yes, that's. We can talk about it now.
Let's talk about it now.
Regarding the scheduling for committees this coming month or so, we only have one new complaint. And so there may not be a need for other committees to meet except for their standing business.
So all the complaint committee or the complaint level, there's
except for Trabeau.
Oh, really? So, wow.
We might have one Tedeschi item.
Okay, but we have a backlog of
for the task force.
For the task force.
So we may want to consider doubling up on the task force. We need to review that list with Chair Wolf and decide, because a lot of them are long-term issues that we still need to work out.
Right. Okay.
And that would bring, as long as we're talking about EOTC, the only thing we have pending for your committee is the talks about the mayor's duties to oversee sunshine for the various departments.
Mm-hmm.
That's all we have. Would you still like to have that meeting on the 3rd?
That'd
Tuesday?
be the 19th, right?
Yes.
Let's go ahead and skip it.
Okay. And we'll have one or two complaints to go along with that. And then the rules will be meeting on that following week on the 26th. And I don't have anything for the complaint committee at this time, so there's a good possibility we may ask to cancel.
Okay. All right. I'd like to see if we can kind of get some outreach to folks. I know there are folks out in the community that when I start talking about sunshine, they get very interested because they have concerns or problems or dealing with certain departments, whether it's Park and Rec or DPW, whatever. And interestingly enough, DPW does not have a commission. There's no oversight commission for DPW. But DBI has one. So and then DPW is everywhere. All the streets are dug up. But it may be interesting. We've had some interesting issues where we've had departments that will just unilaterally convert a IDR into a standard 6721 request. And there's no authority for anybody to do that. So, there could be some good outreach to be done. Somebody, people can call the department head and say, hey, if you have a department meeting, I'd like to come speak for 15 minutes and tell you, don't do this. Or something like that. I don't know. It's just a thought. Maybe at an EOT meeting, you can talk about maybe something simple. In past years, we've got printed like FAQ brochures, about different aspects that we hold to be true for sunshine, that kind of thing. That could be disseminated, that kind of thing. So just a thought.
Before you move on that EOTC mayor's item, I just wanted to let you know that when that matter was referred to committee, the complaint was already ruled on, and there was no referral for compliance or anything of that nature. So therefore, we created a separate hearing file to talk about the subject matter, as the parties are no longer involved in the larger issue.
Okay. So it's a general public interest?
Yes, it shouldn't have been referred to committee as that file. Just a new hearing file was opened up.
Okay, great. Well, yeah, I'd like to possibly sit in on that. That'd be interesting. Okay, on information technology, any word from the clerk's office on new
You're,
database?
you're definitely in our minds, but we're still trying to get our own set up, and we're having, as usual with any new program or contracting, we're having some disputes with the contractor, and we're
right.
trying to resolve it.
Okay. I don't know. I may ping. Who's here good in IT? Josh Wolf. Anybody? Are you? So all our orders of determination are in PDF, but they're searchable. And I'm wondering if maybe we can find an open source database that can do search PDFs. I think there is such a couple of projects out there. Sorry? Yeah, something like that, just to, kind of test it out and see if we can get something rolling. And if it's got, kind of the ability to export whatever queries or search words or something.
Google was for a while reaching out to government entities. Especially, I know they're working with a lot of the recorders' offices to put OCR searches on a lot of the records because people come in and want to search an address and you can't search addresses, for example, in recorded documents. So I know some counties, I'm not sure any in California. I know Macomb County in Michigan was a big one. But I know they were doing that. I don't know if there was a fee involved, but that might be.
Well, the other thing is,
I know they were doing that a few years ago.
Yeah, the other thing is to go to Code for America, which is right around the corner. And they've been working with the city and city departments. They've created a lot of very interesting online services and programs. A lot of the city departments that currently have had overhauls on their database systems came out of projects from Code for America. So I don't know, just a thought, just to kind of get us going so we have something. I mean, all our PDFs are searchable. They're not image scanned. So at least, not the ODs. The agenda item documents have some. Those are there are more image scans in those. So I don't know. Just a thought. We can email each other and figure out if we can do a little search around the open source network and see what we can find.
What's stopping us from converting them all to RDFs?
And
there's a lot more database functionality that you can use with text files over PDFs.
I don't see there being any problem with that for the purposes of the searchable database. Yeah.
Right.
Yeah, we'd still post them as PDF
of
on
course,
the website, but no, I don't see any problem with that. I'm sure you can probably find a database that'll take an import of a PDF and convert it for you.
Maybe that's a different thing.
We could ask CoFam what they use.
All right. Okay. Next item.
Chair's report, item number 13.
Yeah. So anyway, the one item I was going to bring up was that I mentioned before. We don't have much else to report. I just wanted to check in with everybody to make sure everything's going okay. Do you need any additional supported resources? Do you need any further orientations? Are there any outstanding, questions that we might have? Yep.
What's your new dog's name?
Oh,
Yeah, that was.
her name is Yukon. Yeah. And the 10th member, yes. The 11th member.
11th member.
Yeah.
Honorary member.
The only other thing I wanted to maybe, well, first of all, thank you for your indulgence today. This was kind of a difficult meeting for me. There's a lot to kind of juggle and try to participate at the same time. It's a little difficult. I would really urge folks to try to participate and join in the fray a little bit more. So keep hearing the same voices over and over again. So not an admonishment, it's an invitation. So I wanted to just mention that. And also, sorry?
I said I've never had the problem.
And I do think it might be an interesting discussion in maybe in the Rules Committee to talk a little bit about what came up earlier with the discrepancy in the vote
Yeah.
for the
Yeah, that was
because that kind of threw me for a loop a little.
Yeah.
It's been so long that I've had to even think about the 6-vote
Right.
margin for
Right. And that's
for
good.
substant. And frankly, I didn't recall that that jurisdiction
It
was
also-
actually substantive. But yes, it is definitely substantive.
It's also one of my pet peeves, and we've talked about
Why do
this.
we
It said,
need-
why do
why
we
do
need
we need
six?
six
No,
The majority.
I know.
But
Yeah,
Not too much on the record, please. But yeah, I don't think it much matters. Those people are not here anymore that really care about that issue. But
I do.
I mean,
no. I'm saying the people who appoint us. Not many of them are here anymore who care about that issue. I think.
As long as we don't repeat the same thing.
Yeah, I mean, it's reading the bylaws. The opening line of that is 6 members constitutes a quorum. So the next one is there needs to be 6 votes for substantive issues to be approved. So it kind of goes hand in hand with that, but at the same time, it goes for a full quorum too. So a full participation too. So, but I think the question that Member Josh Wolf brought up, as far as the 5-4 decision, it fails, that kind of thing. I think it's worth exploring on a just a kind of rules of order kind of kind of thing, just to get some clarification. So it's not there's kind of a void in there somewhere. So it would be good if anybody has any ideas. If you talk to a parliamentarian, maybe they have an idea on how. That's probably the best person to talk to is a parliamentarian.
We'll take it up.
Yeah. Okay. Good. And that's all I have. If you have any questions for me, I'm open for that. Okay. Just want to also notify you in April. Usually by the end, it'll probably be in the April meeting, but by the end of April, we usually have officer elections. So I just wanted you to open that up for you guys, and if anybody's interested, step it on up. Okay. Otherwise, I'm still happy to do all this work on your behalf.
we're happy to have you do it.
I figured. Okay. Next item.
Item number 14, staff report, complaints, and communications.
I believe we can be really, really brief. Everything is pretty standard. Not much has changed. The only thing I want to know is the communications from Audrey Cooper.
Sorry, before we get to that, can you do the subcommittees? We were starting to talk about that.
Oh, I believe that we kind of set the schedule. The EOTC will meet. Rules will be meeting on the following week on March 26th at 4 o'clock. You actually can choose your time or change it. Most likely complaints, if nothing else comes in, we will probably cancel that.
Yeah.
That's about it for the schedule for the next month. We haven't been getting a lot of new complaints this year, so it's keeping us.
We're doing other things.
There are quite a few scheduled for the full task force that we need to get to, so we may want to consider a special meeting in the next few months once we get our things lined up. And we do have one piece of communications from Audrey Cooper. I also want to note that Ben Kopp has resigned from the Ethics Commission as of Monday.
Okay, that's good. I have a question. With regards to, I don't remember which one of Mr. Smith's cases, but he seemed to be working through you, Cheryl.
Mm-hmm.
Why was he not working directly with the respondent? Did he ask for your assistance?
No, he really didn't. He's just been sending me emails.
So, okay, so I'm just a little concerned about your time. I mean, I know part of the job is to sometimes help expedite, people, they're not sure whether they should make a complaint or not. Sometimes you can make a phone call and say, hey,
I do that.
Right. So,
I have a question.
but this one seemed a little extensive.
Well, the initial complaint was very, very confusing. He had 5 or 6 different requests. I had to separate them out into this was request 1, this was request 2, 3, 4, 5. And I had to get him to respond to each part. And that's where we started. And at this point, he just continuously sends us emails. And at this point, we're just putting them in the file.
Okay.
We're not really analyzing or critiquing anything.
Yeah. I would just say, as if you're able to expedite something, great. That's very great service to the public to do. But I think too much of it is, and kind of it leading up to a complaint,
Well, the complaint was filed before any of this.
Okay. All right. It just seemed like he started out asking, 5. It seemed like his request was made to Cheryl to ask the museums for all this information.
Victor and
the
I
way
reviewed
read
it together.
Okay.
We did. And,
Okay. All right.
It's like 2 pages, just different things.
And then there was, we had so many committee meetings on this matter with requests going back and forth from the committee.
Yeah.
Mm-hmm.
That's probably part of it.
Okay.
Where the committee was asking for certain actions to be done.
Okay. I'm wondering if we could also, if Member Martin, if maybe we can work together some way to see if we can consolidate some of the stuff before we agendize it. So,
I think that's helpful. It just provides for commission efficiency.
Right. And then it helps when it comes to me for the full board,
Right.
for the full task force for making an agenda. So everything isn't, we don't want to do a lot of convolution. I think the 2 cases that we heard tonight could have been combined.
Oh, correct. Yeah.
So because we were just rehashing
Right.
a lot of same stuff. So, all right. Yeah. Efficiency, we try our best, right? Okay. Anything else on this for staff? Okay.
Just take a look at the letter.
Yeah.
We've had.
Did they didn't, Ms. Cooper didn't file a complaint,
No,
did she?
she's just. I'm writing to request that you take action to resolve the situation. This was addressed to Stephanie Cushing. We were CC'd.
Oh, yeah. Okay. Right. It's an interesting issue. Definitely sunshine related.
And we would have put this on the February agenda, but we actually got it February 5th, so there wasn't enough time.
Oh, okay. Was there any request for us to do anything with it?
No.
Okay.
It's just
communication?
Yeah, it's a
Okay.
communication that we got about a Chronicle reporter.
Okay. All right, great. Okay, next item.
Oh, where am I? Item number 15, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Next item. Any public comment on anything? No public to comment.
No public.
So,
all right.
I have a question. So, was Rick me here just to be here? I just assumed he had like some kind of more to say. And
His main thrust was these 2 bills.
Okay.
Just
those, okay.
I will just say they will seriously affect us. I sent it around. I forwarded it. You really, I would urge you beyond that video, read through these. They can have some serious effects, and I would behoove you on your own as open government and transparency advocates. Write letters, testify at hearings, what have you, that kind of thing. Inform, other people, other folks that are interested in this. If you're on other bodies, other commissions, or what have you, people that, this will have a pretty serious effect and really diminish, the level of access. Best way I can put it. So, all right, item 16. Is there a motion to adjourn?
Yeah.
Moved by Member Kanata. Is there a second? Oh, it's by a rising vote. Everybody's going to leave. We're going to lose quorum. Member Yankee, we could take this by acclamation?
Yay.
Okay. If we all leave and we lose quorum, the meeting's over anyway.
You know, I will tell you, Chair Wolf, that I spoke to my boyfriend about this group, and he's going to look into getting somebody.
is your wife not on dog?
Our neighborhood
You said the whole time?
I said the whole time. Oh, my bad.
Great.
Check that out.
Okay, great. Yeah, I belong to the Haight-Ashbury Neighborhood Council, so they get me all the time.
Yeah.
And Peter Warfield shows up all the time, too. And Nick Pasquariello.
He's afraid the world's going to fall apart.
Yes, Mike's.
Yeah,